Well, hello, everyone, and welcome to Uncivil Law. I hope you're having a great day. I've got coffee. I need to move my camera ever so slightly. There we go. Great. And all is well over here on the Uncivil Law channel. I hope you're having a great day. I'm having a great day. For those of you who care about such things, I am now convinced that the problems relating to my PC randomly shutting down yesterday were due to a GPU temperature problem, which I'm also fairly convinced was due to a cable getting tied into one of the fans of the GPU. The GPU has 3 fans, and one of the fans was not spinning, and not spinny fan means hot GPU, and hot GPU means computer go night night. And so I have solved that problem, hopefully. When I took it out after the second crash yesterday, I took the cables out of all the things and pushed them back in. And as long as I was in there, threw in some zip ties because the cables were a little unwieldy, and they now look a lot more managed, which not only prevents the cables from getting into the fan, hopefully again, but also will help with airflow issues because, less sprawly. So hopefully that problem is resolved and we will not have further issues relating to that. So that is exciting and fun. So yay, problem resolved, hopefully. And it makes sense that the GPU was the problem because, yeah, anyways. So all those good things are solved. But yeah, I did a 20-minute completely unnecessary test last night. For those of you who tuned in to watch the fur donut for a while, I did a 20-minute completely unnecessary test where I ran the GPU and CPU at 100% for 20 minutes at the same time just to see what happened. And fortunately, nothing happened, which was kind of what we were hoping for. So, yeah. So all those problems seem solved. Excellent. Yeah. Yeah, not so much as computer not display picture as computer shut down completely because the GPU got so hot that the entire it might be due to the GPU itself just getting hot or due to the ambient temperature, but either way, basically the system shut down to prevent the problem, which is what it's supposed to do. So yeah. There's thermal limits in there to prevent it from cooking itself. So that's what it's supposed to do. And yeah, so problem solved, hopefully. Excellent. Someone said, who thinks Hank's nice guy act is wearing thin? You think there was a nice guy act to wear thin? I'm not so sure about that, but okay, yeah. I'm not so sure, but there was a nice guy act that could be wearing thin, but yeah, all right. But anyways, when we ran the GPU at 100%, the temperature yesterday didn't get above 75°C. So that's perfectly fine. I think the thermal limit for that particular GPU is something like, because I was looking it up yesterday, something like 95°C. So it's running 20 degrees below its thermal limit. So yeah. He's trying with Dr. Russell. Was he? I'll take your word for it. That's not necessarily the way I saw it, but okay. It's not a heat issue. I'm pretty sure it was a heat issue. I'm going with heat issue. If the ambient temperature of the GPU got hot enough that, it caused problems for the motherboard, which is decidedly possible, then it could be due to the motherboard overheating due to the GPU overheating. But either way, I'm pretty sure it was a heat problem. Yeah. Did I clean the fans while I was in there? Well, there wasn't really anything to clean. relating to that because we recently rebuilt the computer when we put in the new power supply. So the entire PC was rebuilt. I mean, using mostly old components, but still, the entire PC was rebuilt like 3 weeks ago. So there is no dust in the case at all because it was just rebuilt. So there's no dust in there. So yeah, it was not a dust issue. There's no dust. It is dustless. What I do to solve the heat issue? Well, I'm pretty sure that one of those GPU fans was caught on a cable and not spinning. And not spinny GPU fan means GPU get hot. I'm pretty sure it was the problem. So having, so we, moved the cables out of the way and then zip tied them so that they would be less sprawly. And so, yeah, good times. Also, Officer Dever reportedly bought an $800,000 house after transferring a pay raise. Nice. It's a desktop. If yeah, it's a desktop. The fact that I told you I rebuilt it was probably a clue. But yeah. Not bad for a 25-year-old kid. I know, man. I'm doing something wrong with my life, I'll tell you what. Apparently becoming a cop was the way to go. Who knew? A $60,000 pay raise, well, that's not necessarily clear because that could be due to overtime rather than her base pay. But still, yeah. Only if you sell your soul. I'm a lawyer, man. I'm already there. Sell my soul, man. What are you talking about? What do you mean? Yeah. I'm glad it seems to be something as simple as just a cable, though, that was somehow, caught up in the system. That is nice to know. Probably should have just used more zip ties in the first place. But oh well. Zip ties inside PC solves many problems. Zip ties help a lot with cable management. Yeah. Yeah. 10 cents worth of zip tie can solve a lot of problems. Yeah. Spinny fan is back. Spinny fan is glorious. All hail Spinny fan. When in doubt, unplug everything and reboot. Yeah, kind of sort of, right? I mean, yeah, that was actually how I discovered the problem. Because someone's like, can you check the the power supply cables? I'm like, okay. So I just literally unplugged and plugged in all the power supply cables again, which seemed a little tedious, but why not? So yeah, it just unplugged all the power supply, including from the motherboard, just unplugged all the power supply and pushed them back in. And then when I did that, I realized, oh, wait a second, there seems to be a cable that seems to be caught on one of the fans. Yeah, that seems to be the problem. Yeah. So putting the cables out and putting them back in again, it's like, oh, okay, that's probably the issue. Do I think Dever still has a job? Hell yes. She towed the line. She absolutely proved her worth in every way. Not only does she still have a job, she will soon get a promotion. I have no doubts in my mind. She did it great. She did the police force proud. She's going to make her promotion no problem. Find a little extra in her Christmas stocking. I have no doubt in my mind. Other police forces around the country are probably also looking to hire her because of how great she is. Yeah. What I probably should do is have some sort of monitor just to see, like, I could have it on my desktop so I could see like the temperatures, like in my in my bar or something, just so I could watch them. That'd be good. Hmm. Her knees are gonna hurt. Yeah, maybe. All the temperatures so far this morning are looking good. I realized I didn't see them on camera after my boss told me I didn't. Pretty much. Yeah, that's kind of what it boiled down to a little bit. Yeah. False memory of Spinny fan. Also, thanks to Tony and Miss Mandy yesterday for being the face of the channel. So that worked out pretty well. They just happened to that turned out to be convenient. So I guess the fates were kind to me in that way. At least when everything crashed, there was someone else to be on stream to entertain you. So that was kind of nice. So thanks for being there and that little. So it wasn't. Sometimes the fates conspire to help you out too. I mean, so excellent. $10 from Greg asked, cops like her are getting on the stand and swearing in front of a jury to tell the truth. Then without hesitation, they protect and lie their asses off. Yeah, a little bit. I don't think she has to worry about that perjury charge. I wouldn't worry about it too much. Blue paint, blue words, and blue wall. Very nice, Dark Cloud. +1 channel point. Very nicely done. She said her jobs depends on what she said on the stand. She did say that. Yeah, there are a couple ways of interpreting that, but yes, she sure said it. I believe AJ did threaten Dever with perjury. Yeah, I buy that. There's only one way to interpret that? No, there's at least a couple. It's like when the police chief says do the right thing. That's capable of being interpreted at least two different ways, right? The right thing by whom? Yeah, do the right thing. Yeah, what does that mean? You said the quiet part out loud a little bit. Yeah. Well, the CPU is a little warm. They threatened to O'Keefe her? Maybe. She sure remembered a lot when Brennan started asking questions. Fair. Whitefield threatened with the word perjury if you're telling the truth. I don't think that that's a fair point. Even if I were telling the truth, if someone said that they were going to charge with perjury, it would get my attention. So I don't feel like that's necessarily fair. It's like if yeah, I don't think like that's fair. Who prepped her? Her union lawyer? We'll never know the answer to that question. It wasn't the prosecution, but it didn't have to be, right? Alexandra Lutz for €5.99. Thank you very much. That's very kind of you. She changed her original story. Liar. That doesn't necessarily make her a liar in and of itself, but certainly makes something sus, which in the context of a lot of other sus things is, worthy unto itself. But people make mistakes. She could have made a mistake. False memories are a thing. She could have been honest or not. Up to you, the members of the jury, to determine whether she was honest or not, I suppose. Good morning, 99 Hour Duke. Computer problems appear to be completely resolved. Thank you. She ruined her future credibility to testify? Not even a little bit. Not even a little bit. Not even a little bit. They're pretty detailed false memories. Yeah, but sometimes false memories can be fairly detailed. Memory is weird. But yeah. Marmalade became an uncivilian. Thank you very much. Good morning, everyone. I love you. You're a good chat most of the time. We need more soundboard noises. That's one of the things we need in my day.
The sun is a deadly laser.
Yeah, we need more soundboard noises.
Aperture Science.
Ah, man. Good morning. Hank Brennan still smells like the mob? From one mob to another. We definitely need more emojis in chat. That's for 100% sure. Yeah, a lot more emojis. Defense is going to have to address Karen's clips. How do I do it? I don't really know the answer to that question. I don't know the answer to that question. The clips remain the biggest problem, as I've said repeatedly. As I've made a point of noting basically every time, confessions or perceived confessions can be and often are enough by themselves, up to and including flat contradiction with other evidence, including physical evidence. So confessions and perceived confessions go a shit long way with a lot of juries. So that was the best part of the state's case and remains the best part of the state's case. They successfully got like 4 different people on the stand to say that they heard Karen Reed say, "I hit him." There was like Jen McCabe. There was like 2 paramedics, and I think maybe a firefighter or something who heard it in the background. So like I think there were 4 people who said that they heard her say, "I hit him." I think. I could double check, but that sounds right in my head. In any event, they got multiple people to say that. And then they interspersed her clips with repetition being the mother of learning. And they interspersed those incredibly well in their case in chief. And juries sometimes eat that shit up, as I've said, on more than a few occasions. So that is a significant problem for the defense. So yeah, there's that. Didn't Carrie admit she lied about that in the Google search? No. No, not really. I thought the paramedic was the only one who heard it. I thought there were like 2 or 3 other ones, although maybe I'm having a false memory. But yeah, I thought there were like, because there was one who heard it in the background. There was one who heard it as they were giving CPR. There was one who heard it in the background. And then I think there was another one too, although I could be mistaken about that. So there was at least 2, and I think there might have been a third. Yeah. Yeah, I think there were at least 2. And I think there might have been a third. Has it come to my own false memory? Quite possibly. It all does bleed together after a while. Could Karen cook her own goose with those interviews? Yeah, very much so. It is a significant liability. Yeah, those interviews are a significant liability for her. So those are significant. That's a significant factor. Kerry Roberts, Jen McCabe, Kate McLaughlin, and Timothy Nuttall. Sounds plausible. In the first trial, they really only sold it as coming from Jen McCabe, who is like just a nightmare woman. So they did a lot better this time of emphasizing those statements from other witnesses. The kids didn't know where or how their dad died. That's rough. Is it true Karen's taking the stand? I cannot believe that Karen Reed would take the stand. That strikes me as impossible. Karen Reed taking the stand seems like the worst idea I've ever heard of in my life. That seems like a disastrous idea. That seems like an absolute disaster. Do I think Karen did those interviews against legal advice? I don't know. Probably. So shitty revealing how the kid's father died? Yeah, I don't know if it is shitty or not. It's a criminal trial, man. Things get said that, you know, it is what it is. So I don't know if that's shitty or not, but it's not necessarily the ideal way to learn. Maybe they should have said something before to the kids about that, since there was a pretty decent chance of that, you know, coming out in one way or another. So the many shitty things Hank's done, I'm not sure that's awesome. You guys in the poll right now are saying who wins in the contest of will. Hank 6%, Dr. Russell 94%.
Hear ye. All persons having anything to do before
Yeah,
the
I think Dr.
Honorable
Russell will be
Beverly
fine.
Canoni, the Justice of the Superior Court, hold an indictum within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Good morning, jurors.
I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from...
Judge Bev, I don't know what we need to do, but could you please not talk to the jurors like, you know, a kindergarten teacher or something? It's a little annoying. Jesus Christ.
discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday? Everyone said no or should be. Is Dr. Russell in the back there? Mr. Brennan, you can set up if you want to.
Yeah, I need to change her description. She's not just an MD. She's a big dick swinging MD.
Good morning, Your Honor.
Looking good, doctor.
May I?
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes,
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
Oh, the link from yesterday doesn't work, Tony? Oh. I thought they were the same every day. All right, never mind. Okay, well, I learned something. The link changes every day. That's good, probably for the best.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered?
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Lessie.
And Mr. Alessi, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so, did Mr. Alessi help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but, you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
Did you have any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so, after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you just
please.
testified to. You want to
Yes,
see it again?
yes.
Okay. And by the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I asked you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
Ooh,
So
Mr.
you and Mr. Alessi, you know there's a sequestration order, don't you?
Ooh.
Yes.
A sequestration order that you're not supposed to discuss the case at all with
Yeah, that's the-
anybody?
Well, we
during your
didn't. We didn't discuss specifics.
Do you know that the sequestration
Contacted
order
who, though?
mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I
order
didn't.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So,
Yeah, especially with this judge, like minding your P's and Q's, because you have a witness on the stand. So a lawyer talking to a witness on the stand, like that raises all kinds of very uncomfortable problems. I'm not accusing necessarily Alessi of doing anything wrong, but it got my attention. And with this judge being, hostile to the defense as she is, I would not be looking to give her an inch. It's like
Not even a little bit.
That sounds problematic, man. Yeah. Okay.
did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday, no. Not in the car yesterday, no.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to this sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver, yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
And the
What
driver.
else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride back to the hotel yesterday, with others in the car, nobody spoke about the case.
Who was
But
in
I'm
the
talking
car
about
yesterday?
this morning when you did speak about the case. What else? Not about the Red
That's-
Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking you about this case.
that was
I-
it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some there must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript.
He might
must
have.
have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he talk?
I'll tell you what. I'll remind I'll remind him every single fucking time.
I don't even know how it
It's
came
always
up.
a good thing.
It was. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
Sage. Nice.
No.
Do you have any memory issues?
Ooh.
No.
May I approach?
Yes.
Ooh. Ouch. Yeah. There might not have been any particular context. It might have just been, by the way. just as a random
Since you
thought,
asked for the
but
transcript, I have
Oh
it
yeah,
for you.
I could see it just popping out.
Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than 100, you couldn't be 100% certain?
That looks consistent.
Do you want more time with the transcript?
No.
Brendan's going to do this every question, isn't he?
Well,
Want the
Ben-
Has
transcript?
anybody else
Want the
talked to you
transcript?
about your testimony today
Sure.
overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date,
Yes,
may I see the
of
transcript?
course.
Pulling the
Yeah.
Jim
Attorney
Cave.
Alessi's advice, let me approach.
I'm gonna strike that, disregard that, Jonas.
May I approach?
Yes.
these say pursuant to Alessi's advice, I'm going to approach. Holy shit, dude.
June 21st, 2024, Doctor?
June 21st.
I'll give him that
Page
one.
23.
I'll give him that. I'll give him that moment of
Line
snark.
14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you. Gonna have that back?
Yes, you may.
Okay, thank you. When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word, or adopted the word possibly, didn't you?
Explain the context of it?
Sure.
That sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
Then, I'm sorry, please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Do you remember all those questions you were asked?
No.
In June?
Yesterday.
Yesterday, okay, yes.
Yes.
Probably
And
not
when
even,
you were
to
asked
be
about
honest.
methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest there's some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes?
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you describe methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about. the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There
For
is no
instance.
standard. There is no recognized standard anywhere for methodology on how to identify
No, not
a
really.
dog
No,
bite.
I mean,
wound.
why
Is
would there
there?
be? I mean,
There
dog
is
bites are not
no
exactly
published
a high
standard
whodunit.
from an organization that
Right.
I am aware of.
I had to invent it.
So there is no source. There is no
I am the source. I am
recognized
the OG.
community.
Fuck
There's
you.
no certification. There is no recognized method in
Certified myself
identifying
too. Fuck you.
a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
Probably not.
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards.
No,
There is nowhere
there's
you can point to
the
where
AMA
the
or
so-called
NIST does not
methodology
have
that
its,
you were
you know, follow the
telling the jury
ISO
yesterday
protocol, blah,
is
blah,
a readily
blah.
accepted standard
know.
in the dog bite community. You can't point to anywhere, can you?
There are peer review articles which list recommendations on
Yeah.
how
Are
to
there peer
determine
review
something is
articles on
from
how
some
a
wounds are from a
car
dog.
tail light
These are
breaks
peer
into
review
43
articles
pieces
written
and
by,
causes these wounds?
esteemed,
Is there peer review
physicians,
studies on that bullshit?
That have analyzed dog bites and
And incidentally, by the way, by comparison, you didn't have an expert who'd been like, you know what, there aren't, but I invented
particularly a
it.
forensic approach to identifying.
And to the extent you
dog
did, the
bites.
guy had an
Let
associate's
me ask you
degree,
the
so
question
there's
again,
that.
Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for
dog bite
identifying
community.
dog bites? One article, one journal, one book. Can you point to any?
No,
Well, I'm going
bitch.
to mention the articles I mentioned earlier. The article with the lead author of Dr. Demunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
I mean, what sort of case is going to question whether or not it's a dog
And so
bite?
with
Someone
no
says, "Hey, a dog
readily
bit me," they're
accepted
like,
standards
"Yep."
in the dog bite community, no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet
Yep.
doctors make and nurse practitioners and the like make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking.
Yeah, and I, although of course I'm not an MD, I believe the doctors and other people in chat will probably back me up on this contention that medicine, we don't know a lot more than sometimes is generally understood. I mean, we know a lot of things, but there are a lot of things we don't know, and some days it's a little bit more witchcraft than I think we would like to acknowledge, because we're still trying to figure a lot of shit out. And we're still trying to make shit up. So some days it's like, you know what, we're just skating on the edge of knowledge, man. Some days it's a little iffy. Yeah.
talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years.
I don't know whether or not that's true, but isn't it like aspirin or Tylenol or something like even like that? Something where like the mechanism, actually like how it works, they still don't know like exactly. Isn't like one of those basic things, because it was never studied in the first place, because it became well known and well used before, you know, it was ever really figured out how, and then no one really bothered to try to, isn't that like true of like aspirin, Tylenol? Or am I just making shit up? I seem to vaguely recall that being true. I also seem to vaguely recall being true that if they were trying to get it approved today, that they wouldn't be able to, because you couldn't get through the standard protocols today. So it's legacy.
Years.
Someone in chat says, can we just listen to the testimony? No, it's my channel. We talk when I want to. Fuck you.
And the method and the articles that I read, the numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
Well, you say coming up with a methodology. Are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard.
I mean, even
And
if
of course, there's always the placebo fact where it works because we wish it would.
yeah.
Great. What were you going to say?
Oh, just say he's grilling her on no methodology. Somebody has to come up with it. Is anyone more qualified than her to start the process? So I don't see what the problem is.
Yeah, well, yeah.
In the medical community, relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out, you sought the case.
That is incorrect.
And you said you had a strong interest in dogs.
Determined Brendan has a micro.
And that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
I asked 10 experts.
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions?
Was
and
Magic
wounds?
Lexus
What else
in your
before
review?
I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
I would like to put up an exhibit of Mr. O'Keefe's
God,
arm.
Brennan's
Now, I
insufferable
asked you some
sometimes.
questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking
Yeah,
at
where the
these,
studies
they are
saying that the
superficial
Lexus can wind up in
abrasions? Do you
space? I
agree
want to
with
read that study.
characterization?
Yes.
Show me that study.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for the sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2,
Yes.
number 3,
Yes.
4,
Yes.
5.
Which did you call
sorry, this
4?
one,
4,
five.
5, 6, maybe.
Okay. So as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Okay.
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the transcript.
Do you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
From a year ago, probably not exactly word for word, no.
Do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion-
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me
Talk
ask
to your
you
experts
before we
about
talk
that.
about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them
They
when
can
you're
be.
looking at
I
a
think that's
wound?
what she just said, yes.
I'm saying that they can cause similar-looking abrasions.
Are
Yeah,
you
one is-
able,
one is
as
pointy,
premier
the other one's
expert in the
pointy.
United States on dog bites, able to tell the difference between teeth and claw nails?
Not
of
in
an
every
animal
case.
When you're looking at
Sometimes you can't tell.
Individually,
Especially not from
well,
pictures.
okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
Well, when you first started testifying in this case, you never suggested
this
you
case,
had
it
to look
doesn't
at
matter if it's
everything in
teeth or
totality.
claws.
You
The
were
fact it
giving
came from a
opinions
dog is all
regarding
that matters.
individual wounds. Isn't that fair to say?
No,
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
Right, that makes
I
sense to me.
disagree with that. I believe that the very first time I testified, I mentioned that the overall pattern was important.
When you first
I don't understand what's confusing about that. It's like if you have one thing by itself, it may not be sufficient markers to be able to tell. It's possible it could be, but you might not have enough markers. But if you look at other markers, for example, how they align with other wounds, then that gives you more information. And be like, okay, this one by itself, I'm not so sure, but because of the pattern of this, I'm like, oh, it's probably more this or probably more that. How's that confusing? I don't understand.
Well, that's exactly what Welter was saying. This is a whole pattern of cuts on his arm from the taillight. It's like you didn't match a specific piece of glass to each wound, did you?
Yeah, no. Yeah, so yeah. Okay. All right.
testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying to a reasonable degree of medical certainty.
I'm not sure that's what she
Teeth,
did
isn't
say,
it?
based on what you just
No,
said.
there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Okay. Nails on a dog, oftentimes or most times, are horseshoe shaped, aren't they?
No.
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it
I mean,
depends on
slightly,
the
but-
grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, you know, at the end of the paw. They come to a point, and by the way, the paws can open and close, so the distance between the nails can vary depending on you know, on the how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think
Just as
that
like
the
it's
teeth in a
possible
dog
to
are
Alexis
different
to
shapes and
space.
sizes?
Oh yes, depending
It's-
on the tooth, there's
It's a lot
different
more
shapes and
possible
sizes.
than the
Absolutely.
Lexus Space
When
Lexus, I'll tell you that.
testified the first time, and you said that you thought it was teeth or nails. Teeth or nails. Do you remember testifying a couple days later in front of a group of people, and you again iterated that this could be teeth or claw marks? That was your testimony last year. Teeth or claw marks, right?
Yeah. Do you know what a claw mark is? Wouldn't that be a nail?
Prior proceeding, folks. That's
What's the
all.
difference between a claw and a nail?
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
I mean, what does it matter?
It could be. She's saying no, it could be, but she's also saying to a degree of medical certainty, she thinks it's one thing versus the other. I don't even know what point we're trying to raise right now. I'm confused.
I think it's been a pattern with Brennan. He just wants sound bites for him to stitch together in his closing argument.
Yes.
That no individual
Yeah.
point scores anything until you bring it all together.
Which, you know, fair enough, I suppose.
When you first testified on June 18th, doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony. On
If he
page
can
37.
avoid being a smarmy
Line 7, the
ass,
questions begin.
you know, if he can organize it well, he might be able to crush it and close too.
Read any part you want, but line 7 might be it.
So,
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay.
That was your first testimony last year, yes?
Yes.
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report,
Yes.
after your consultations, do you remember changing that opinion regarding Number one. Do you remember changing that opinion?
No.
I mean, it
Do you
changed
remember-
the certainty that she had, but
Changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yeah.
Yes.
Okay. The pointy teeth, the big ones, those are called canines,
Correct.
and the smaller ones are incisors.
Correct.
There are 6 incisors in a healthy dog on the top and bottom between the canines.
Correct.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did your report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified, December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged, and each time I reviewed the case, I became more certain that these were from canine teeth. And actually, there's other marks there, but these are from teeth.
You say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth.
Top-
Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there. And the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
I'm going to allow.
Do you remember that conversation? You said that the point of entry would be the bigger circle, pulled this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that at all.
Remember that conversation
No.
we had? Okay. And so, inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound up
Yes.
there, closest, I agree, yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of
Can we
these
get
just
some
so we're clear.
objections for asked
Same
and
thing
answered
with
at
number
this point?
3. You've provided opinions on this before.
Yes, not that
If
make
you
a
look at
difference.
this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
4, pardon me, yep, 4, same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for 5 and same for 6.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number 2, what caused this wound, Dr. Russell?
Number 2, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny pinpoint almost lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number 2, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today, anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these two scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second.
I'll look at the spacing on the far left and the far right. Looks pretty consistent.
Not exact. These two linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently, Mr.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
I'm going to object to the word that was used that's been done before.
Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Can
approach?
you just hold 1 second? Could you please turn the fan off, Paul? Juries, is it okay if we turn the fan off so we can hear better? Thank you very much, Officer DeLong.
Can't you guys get some better speakers or something? I don't know, man.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound, December, and I asked whether you changed your opinion from teeth or claws to just teeth. Weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay.
Can you
I
read,
said,
Brennan?
I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent in scissor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder, and then the sentence, but I'm not sure on the second set, so this is the set that's just above the elbow. I said I'm not sure.
And then, sorry.
Oh, go ahead.
Are you done?
Oh.
Yeah, transcript isn't going to show us what was actually being pointed out on screen.
Yeah, actually, I did make
Put it
another
together.
comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper and these are from lower. That's what I was referring to.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter-of-factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today, you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You
Yes.
were asked, what do you think? And you didn't say, well, not 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What about engineering certainty?
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two are caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell. A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the arm?
exactly what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I
When
don't
the
care
bee
if it's
stings?
a law enforcement dog or a domestic dog.
When you're feeling sad?
You know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes and coincidentally every single one of them lacks any wound to the underside of his arm?
Yes.
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical
Could be isn't
opinions,
necessarily
your
speculation.
medical opinions. Do you have any evidence that the dog's lower jaw, you said
It's an
maybe
opinion, you
upper, maybe-
jackass.
that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But yes, I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Yes, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, can you put that back up, please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be
Well, do you have the
specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
Thank you.
Do you have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's 2 linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends, it depresses. So you could have 2 prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it?
Again,
Objection, Your Honor.
So there was a question at that, so I'm going to let that in.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by 2 canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What did you come up with?
Visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did
measure
not.
them? Did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would
Because
you
it's
even
an
do
approximation.
It if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper, a report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is, it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, Doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember
It's
using that
exciting.
term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with the car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition
So
methodologies.
if you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Uh-huh.
Yes, I don't know how to answer that.
Well, try.
Can you be more specific?
If
She
you're
knows
going
something
to
about
say
collisions.
that
She's seen a couple
these
collisions in her
superficial
day.
abrasions
Yeah,
could not have
lots.
been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision.
Not really.
don't you?
No?
Actually, I disagree.
Yeah.
However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that forms a basis for
That sounds right to me.
It's the same
the only
basis
thing-
they use for their neurosurgeon.
Did you finish
Was
that answer?
recognition
No,
of
no,
wounds.
no.
You
Did I
see.
cut you off?
Yeah, you don't really need to know the mechanism of action. From your point of view, it can be a magic black box. It's like car, something leads to these injuries. It's like you don't need to know exactly. You just know if car, something magic occurs, leads to these injuries. And you've seen 1,000 of them, so you understand what a car injury looks like. So you don't need to know them exactly how that works. You just like, I've seen 1,000 car incidents, so I know what a car incident looks like. How does the car create those injuries? I don't know, magic, but I know what it looks like when it does. So I'm there. Yeah, that's like that works for me. Yeah.
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case?
Yes. Yes.
I didn't have a lot of information, that's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
No.
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of accident
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
No, she is not. Among her many credentials is not the ACTAR.
Are you ACTAR qualified?
You know, coincidentally, Trooper Paul's
No, and I don't know any physicians that are.
It's probably the
Have you ever
exact
gone
same as
to a
what she
scene
has.
of a car collision?
So please, if
and
Trooper
done
Paul
an
shows up,
investigation
bring this up. By
and
all
written a
means.
report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Again, she doesn't.
Beyond the
Again, she doesn't need to know how it happened. That's the thing. Like, she doesn't need to know how the car caused the injury. An accident reconstruction expert would tell you how the car did what it did. She doesn't need to know that. For her, from her point of view, it's a magic black box, because she just knows from being a medical examiner and doctor and all the rest of it what a car collision looks like. So it's like, what is the mechanism? How did the car create the injuries? For her, from her point of view, it's a magic black box. But she can still recognize what a car incident looks like because she's seen 1,000 of them. So it's sort of dumb.
Well, even Welcher, the reconstruction expert, couldn't tell us exactly how it happened. It was his 1 in a million scenario that it could maybe have happened this way.
Yeah. Okay.
So these certifications get you nothing.
Expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Magic Space Lexus?
Yes. Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those
Russell,
factors.
do you know what 5 inches looks like?
Studied.
Opinion. Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if
she doesn't
it was
need to
similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
She doesn't need to.
I have looked at photographs.
And when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight. Did you notice that?
Objection, fact,
I
not
noticed
evidence.
that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022 at about 12:32
Well, in order to
a.m.,
get
right
into
around the
space, it
time
would be
that you
traveling,
think
what is
these wounds
that?
happened?
What's the escape
I
velocity
have-
again? Isn't it like 23,000 miles an
I have
hour?
some knowledge of the
I'd have to
alleged
double check
speed
on that.
at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay.
You mean,
Not 2 inches of
warm
snow.
body melts
The
snow?
ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass
Have you ever
in the
looked
picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his
Genesis?
pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence.
Was
of
the ground
grass
as hard
on
as
the
a rock?
pants.
Did you ever actually look at
I
the
don't.
pants?
I don't know if I looked at the pants.
So
To
when you
tell
say
you
you
the
didn't
truth.
see any evidence, are you saying you didn't look or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants, photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as
So
possible?
let's, we'll come to sidebar, Mr. Herman.
Sidebar.
Come on, Hank. You know when they call objection, you got to stop. Don't run over them like that.
Spinny fan. Yeah, spinny
Yep.
fan. Well, while we are enjoying this slight fan break, I will announce our new sponsor, Dragon's Treasure Tea. Dragon's Treasure provides tea and coffee, and I can say that their tea is actually extremely good. They make very good fresh tea, and you can get 10% off with code UNCIVIL. And now also, for me, they make coffee, which is more my speed.
Ooh.
So you can get some coffee of different flavors and stuff from Dragon's Treasure at thedragonstreasure.com. Discount code UNCIVIL. They also got some soap. Soap is good. Nice soaps, teas, other good stuff. Check it out.
Suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle. Did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth, or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No, you asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very
So
close,
Hank is
no.
creating
Did you
uncertainty
see
on
the
their
bushes
theory
in
of the case.
photographs near where Mr. O'Keefe lay?
These are more plausible,
Right where he laid, no.
reasonable.
How about next to
might
him on
say.
the left? Did you see those bushes?
There
Talking about
there was
bushes
some
now?
other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are there instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries, correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable
If you can show me some cases where there's not even bruising, I'd be interested. But yeah, that seems, yeah.
factors. Isn't that fair to say?
Yes.
When a vehicle's involved, have you ever been involved in treating patients that received injuries from broken plastic or broken glass in a car?
Yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering,
I'm a little concerned that these questions are going to be more effective than I think perhaps you or I necessarily want to give it credit for. I think these questions, especially in a closing argument, depending on other details, but like even this doctor is basically saying that you could have, because it answers the question that, you know, is sort of lurking about the issues relating to it. Now, I don't know whether or not she's seen a case where a person's hit by a car, gets thrown through the air, and doesn't even have bruising. If that case exists, then that might be interesting. But I think even if that case doesn't necessarily exist, there's the implication, which is enough right now. So that answers a question that could satiate someone's reasonable doubt. So I think these questions are better than perhaps than might be giving credit for. So I'm a little concerned about them.
Excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than...
Although also then it still raises the question, assuming that that's true, then also simultaneously, how does he get injured enough to, lead to his death, which is also a bit of problematic. So if you had that scenario,
a lot of Hank's things are okay as long as you don't think about them too long.
Yeah.
And being run over.
Yes, I considered multiple scenarios.
Had you, or do you
It probably is
agree
possible
that injuries from a side
but
swipe,
of course, the standard for us is beyond a reasonable doubt.
could
So
be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
pieces of car?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
Nobody
I
ever
couldn't
marked
tell.
where his body was, so they
On
wouldn't
the
You asked
know.
him a
photographs.
question. I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to
Fair.
cause those injuries, lining up in a certain fashion to cause those regular striations.
Good
Rather
answer.
than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian, yes. Not as a medical expert.
Could I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that that there was one shoe off, correct?
Were you aware that it was wedged right up against the curb? Were you aware of that?
I have been aware of that, yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
What color is the sole
Could I have
of the
Exhibit
shoe?
99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat there was not 2 inches of snow? It looks like dirt and grass.
It's been stepped
Yes.
on. You can't tell that.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be. If the ground was frozen, if it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
Are we going to do this for every
I considered that there
piece
would
of
be
plastic
several
they
pieces
found?
of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
Large red pieces they could not find when there were only like 3 or 4 inches on the ground to
You
start
can take
with.
that down, please.
If
Would
that,
there
yeah.
be any
Yeah.
significance in your study that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken and missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours.
Yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having a trouble
Okay.
understanding the
It's
question.
my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes.
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle, yes?
That's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes.
And you learned that her right rear taillight was broken and missing pieces, yes?
Yes.
Did you want to know if there was any evidence depicting when that taillight was broken, in considering this conclusion?
Yes.
Did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces.
Incorrect.
I'm going to allow that.
Oh, come on. That's up to
Not
the
at the
jury to
time,
decide.
but I expected that if there were a collision, that there would be pieces of the car, involved. So it didn't really
On
make
that.
any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time it?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in a certain pattern to give those parallel marks all in the same direction.
Yeah.
So, that's why a broken taillight could not have done that.
So you, in your investigation, you did not want to know when that taillight was broken?
Oh, I did, but for information only.
Did you
Yeah, it'd be
review
irrelevant.
the ring video
Yeah, it
from
doesn't matter.
5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Would that be, I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10,
Hank's going to use
it
this.
actually was from a video. Did you look at this picture during your
Defense's
differential
own
diagnosis?
I think I've seen that
expert
picture
said the
before.
taillight
Yeah.
was broken.
Could you have
The vehicle parked, yes.
Exhibit 11,
He's
please.
scoring more points
Yeah.
than.
Did you consider this picture in your differential diagnosis?
Yeah, he's scoring more points, particularly across.
I don't know
or
that I
particularly in the
ever
close
saw this
at-
picture.
Yeah.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I do not. I see it
I
like the
can't
snow.
even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision, do you listen to witness testimony or do you review witness statements?
I'm going to allow that. Just,
That's
do you
true.
do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No. What do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about? Did I hit him or something of that? What do you mean specifically?
Have you seen
She
any
said
of
a
the
few.
media statements
Yeah.
by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact, a collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow.
Okay.
And so after a stressful event, many people suffer from what's called an acute grief reaction.
Thank God.
It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this.
Thank God for getting this concept in front of the jury. This is a common sense thing, but thank God that I don't know why Brennan's like giving her this door to just basically explain this psychologically, but thank God someone said it. Yes, she basically could have been hysterical and saying all kinds of shit that isn't necessarily connected to anything because of trauma and all the rest of it. So thank God.
Hank's gonna have getting this.
Oh, I'm sure there's many exciting follow-ups, but I'm just like, thank God that she's saying this because it gives the ability for a defense team to use that wonderful thing in their clothes. So thank God for that. Damn.
Many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, sure. Yes.
Does it happen months later when you go on 20/20 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Fair.
Now,
Thanks.
when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware.
I don't think that was the answer you were hoping for, Brennan. So that was the wrong question. It's like moving on to other things. Yeah. Well, thank God for that small favors.
That those clothes were swabbed for DNA traces, weren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have Exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that
the defense team does not take the opportunity to ask questions more about the issue, the stress reaction, and more about her experience as a ER worker. If they don't spend more time on that, I will be a sad panda because there's a lot of opportunity.
She's worked a lot of,
she's worked at a lot of emergency rooms. I'm sure she's heard a lot of things from a lot of people that don't make sense. And so if they don't spend some quality time on that, then shame on them because there's a great opportunity to ask some quality questions on that. It's like, have you ever heard, basically family members taking responsibility for things that were clearly not their fault? Yes, I'm sure she has. Yeah, many times. Yeah. So let's spend some Q&A on that.
those holes were swabbed for traces of dog DNA?
Objection, Your Honor. I'd like to approach, please.
Okay, come on up.
Sidebar. Exciting. So we've had some good and we've got some bad, right? We've got points scored kind of for both parties. We've got points scored for Brennan bringing the concept of the confessions, which it is what it is. We got the ability to try to explain it away, which thank God someone's bringing that in. And then we also got issues relating to the medical issues relating to how you can, at least in principle, be hit by a car and perhaps not necessarily be significantly worse for wear, even at high speeds, which I totally buy that's possible. I think it's possible that a pedestrian could be hit by a car even going 20 miles an hour and, fly through the air and potentially be no worse for wear. But, how much you factor that in, but at least there's things there to be. So I think there was more there than, my chat or the LawTube chats necessarily wants to acknowledge. I think Brandon scored some points.
Oh yeah, he got
some stuff in that was potentially useful for him. So, there's some factors there, and but there was a nice little rejoinder for the defense as well. So a little bit of something from everybody. Defense has some work to do on redirect for sure.
Oh, for sure.
They've got to definitely bang the excited delirium, panic, just complete delusional, disassociation angle. They got to hammer that for a while, and then they've got to do something with the issues relating to. And she did a good job with, incidentally, like trying to rebuff some of that with the taillight pieces couldn't possibly have caused this, because she's right. Like even if the taillight pieces cause the injuries, like how they all cause them to be in parallel doesn't really make sense. And so she there was some good stuff there, but there were some points for Brennan that I think, because the issue relating to the incident occurring and the causality are the biggest problems. And like, there is now a hand wave away explanation of some of that, and that's not nothing.
Yeah. Well, yeah, she definitely went to the point of talking about the taillight causing the injuries. If we had a picture of the taillight, you'll notice that it's like one single long edge that's got like one V in it, and it's really wide. It would have left one slice. In order to get drag marks, that would have had to have shattered, dug into him, pulled through him, and then shattered further in order to cause those wounds. When that taillight shatters, it's just going to be instantaneous, and it's all going to just start falling. It's not going to grab his arm. It's not going to pull unless it remained attached to the housing. And she said that unless it's got multiple teeth sticking out of it that all pull in one direction simultaneously, it's not possible.
And I don't know the degree to which Brandon wants to go this direction, but he could kind of concede the point and still get to where he wants to be.
Than, any of us wanted to do while you're sitting here. So we're going to continue what we're doing, but we will give you the morning recess. So that's
So some sort of like issues related. So the jury gets a break.
Follow me.
What was I saying before I lost my train of thought?
Mechanism of injury being consistent, I think.
Yeah. So there's definitely some things there. But I think Brendan definitely scored some points with trying to hand wave away the. Oh, I was going to say, let me say this before I lose my train of thought again. He could also go a different direction. He could even concede the point, even softly, that the injuries to the arm were caused by a dog, but the accident still occurred nevertheless. So it's like, that's a way you could go, like, because those are not mutually inconsistent principles. John O'Keefe was hit by the car. He was disabled in some way that prevented him from getting up. While he was still alive, perhaps struggling on the ground or perhaps unconscious or whatever, as the case may be, a dog or other animal attacked him. Those injuries on the arm were caused by a dog, but that he was still hit by the car and he was rendered unconscious, and that was the cause of death. And if you buy that, then you're there in terms of murder, right? Because what you need, or I mean, you could be there in terms of murder. It's like, what you need is that she deliberately, intentionally backed up the car with knowledge that John O'Keefe was there, recklessly endangering, basically, that she hit him, and then that through some mechanism of action that then led to his death, whatever it was, due to some sort of combination of hypothermia and even or a dog attack. If he was rendered unconscious or disabled or vulnerable because of the car and the dog attacked him, and then the dog in some sense led to the death, she would still be responsible for that.
Oh, yeah.
Because it was because of her creating the disability, the dog was then able to kill him. So
Yeah.
it would not be sufficiently intervening cause. So he could steer into the skid, as it were, and be like, sure, the injuries were caused by a dog. What of it? Fuck you. I still can get to my murder conviction. And he would be right, assuming that you can buy all the predicates for it.
Yep.
So that is another angle he could go if he wanted to go that direction. So that was my other thought. So because of that, if he wants to go that way, he has opportunities to be like, yeah, it's a dog, so fucking what, and I still win. And if again with the idea that a person could be hit by a car in such a way that they wouldn't necessarily leave bruising, although, yeah, I mean, basically what would have to happen, and it's not impossible in this scenario, what would have to happen is that he would be hit by the car.
Mm-hmm.
He would be hit by the car. The car itself does not create injuries, but when he hits the ground, basically his head hits the ground.
Yep.
And that is the thing that's disabling. And so the car injury itself did not create any bruising or torn things. It was when his head hit the ground. And basically that was the end of John O'Keefe. And that is a plausible scenario because sometimes people fall and sometimes they hit the ground in the right way, particularly if the ground is hard. And sometimes that's the end of that story. So if you buy that combination of events, which is plausible, then the sort of the legal question is, how do you believe it to be beyond a reasonable doubt standard? And depending on what you choose to focus on and what you don't choose to focus on, depending on what you choose to credit, depending on how much you're willing to let certain things smooth out, there are more ways of getting to a conviction than I think we started with at the beginning of the day. I think she gave a critical piece of the puzzle to the Commonwealth that gives them additional outs, if you like a card playing analogy, that could get them to a conviction. So my concerns for a conviction remain present. So that was my thought before I interrupted myself. Do you have anything that you want to comment relating to that?
That pretty much covers it. Well, I don't know if Hank will bite on using that directly, but it's there for a juror to pick up, certainly, and use it as an excuse to get too guilty.
Yeah, I think so. Apparently, there's an argument for a mistrial in progress, so we'll resume for the argument for a mistrial, which, by the way, will absolutely not be granted, but we'll watch it.
No.
Ma'am, watch your step coming down. Follow me.
Jury is exited the courtroom. Please be seated.
All right,
Dr.
Mr.
Russell
Alessi,
even
I'll
gets
hear
to
you.
walk out.
Mr. Alessi, I'll hear you.
Thank you, Your Honor.
Excuse me, Mr. Brennan.
Mr. Brennan, can you remove? Oh, okay. It's being removed.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic.
No.
Ms. Reed is entitled, under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Okay, yeah, I like a lot of what he says in terms of this idea. So the problem, by the way, here is, as he says, like the state, of course, during its case in chief, has to introduce all the evidence it wants to bring to bear. And in their rebuttal case, of course, they can only rebut what the defense mentions, because if the defense never brings on a case, then there's no rebuttal case because there's nothing to rebut. So they can only rebut what the defense brings in. So if the defense never mentions DNA, then they can't bring in an expert to talk about DNA because the defense never brought it up. So he can't introduce the concept for the first time and then be like, oh, I'm going to cure it in my rebuttal case. That doesn't work, because it's only because of what the defense introduces that he could introduce in the rebuttal case. And, obviously as he says, the defense didn't introduce it. And so, there's a lot of merit to that idea. And they put into this element that is new, and basically trying to make part of their case through the defense's case, which they can't do. So yeah, there's a lot of merit to that idea, but let's see what Brennan has to say about it. This will be fun.
I think Bev's got a whole lineup though of lesser remedies than mistrial.
Yeah. I mean, she's not going to do that. First of all, she's probably not going to do anything. And even if she did something, it would be like it would just be a cautionary instruction, and the Court of Appeals would be like,
Yeah,
yeah,
that's
that's
all
fine.
it's going to be.
It'd be fine. It'd be fine.
Okay, thank you. Mr. Brennan?
All right, this should be interesting.
Oh yeah, this is going to be a giant load.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury.
The evidence doesn't
Let's be
exist
clear.
yet, bud.
The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear, the defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA
That doesn't work.
in her opinion. She disregarded it. She discounted it. She created false theories about the potential destruction of it.
Yeah, it doesn't work.
She did testify this was part of her consideration for her opinions. Again, on January 7th, 2025.
It also doesn't
Dr.
work.
Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient. It might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday. But it is not improper. It's not unconstitutional. It's not irrelevant. It's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea
I'll allow
that
it.
the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions for yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you,
Mr.
Your Honor.
Wilson.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie, that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded,
I think he's a little pissed.
virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
I mean, didn't the DNA place have accreditation issues anyways?
Brandon.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi. Wholly.
All right, thank you. We'll give everybody a half an hour. So.
All right.
She's going to come back with a no. She's going to come back with a no. Of course, she's going to say no.
Yeah, certainly. There's nothing going to happen.
Yep. She wants a half hour so she can figure out how to say no.
Oh yeah, she wants all of her break time, you know. But you know, it's only a woman's life on the line.
Yeah.
Extra break time. We're cutting it off at 4.
The sweater was tested for DNA, but not the wounds themselves, right?
Correct.
Okay. And this doctor knows that. The person testifying, she knows that. And so how does that play legally? That's an interesting question.
Because it's an absence of DNA, so it's not like something you can prove.
Yeah, but they tested it. They tested for it, and they didn't find it. And so,
what they did find, what, pig DNA?
I think so.
Something like that.
Yeah, I'm actually trying to think about the underlying legal issue here, because you can ask the expert anything that she was aware of that would go towards her opinion. And so the state never mentioned DNA, which they, of course, are not required to mention it in the first instance. But she was aware of the lack of DNA. It was tested for DNA. The skin is never tested for DNA, which, be that as it may, but the sweater, because the defense said, or the defense certainly posited, that the sweater was attacked by the dog, because they've talked about the tooth going in and pulling out the sweater. So they're like, so their dog bites are on the sweater. So that is a defense posit. And the fact that there is no dog DNA there would tend to suggest against. It isn't, it isn't dispositive, but it does suggest against. And she's aware of that. And I actually, you know what? I think chat's going to hate me, and I think I'm willing to be corrected by other attorneys on this, but I think the question might actually be proper. I think the question might be legally proper, because the defense is posit that a dog attacked the sweater, and the dog DNA should therefore be found, and there is no DNA there, and there's certainly explanations that are possible to that, because it's not necessarily the case that DNA will necessarily be left behind every time, or it was destroyed or something, but it is it's relevant, because in order for something to be relevant, it only has to make something more in dispute more or less likely by any degree for it to be legally relevant. And so it does make it less likely that it was a dog attack by some measure. And so I think the question might actually be legally proper, but
I'm trying to think of what all of the evidentiary issues were with that, because I don't think they could say what was specifically swabbed, how the item was cared for.
Andre is looking at Commonwealth versus Barbosa. Hank's question is improper because he failed to bring a testing expert to set the foundation. Yeah, I don't know that he needs to, though, because it's a foundation for this witness's testimony. This witness is on the stand, and the defense did ask, right? The defense did ask about the bite marks on the sweater. They asked and said, like, it was because Alessi said that, like, we asked about the mechanics. We asked about the dog tooth, causing the ripping, and so the defense did. And then also the tear. Yeah, the defense did ask. So the foundation for the question. The foundation for the question is in the defense is raising the issue that tooth marks are on that sweater, and that is the foundation for the question about asking for DNA. So yeah, I think the question might be legally proper. We could take a look at the citation.
Yeah.
Let's take a look at this citation, because I think it's an interesting question as a matter of law. And if there's going to be a law tube dispute on this issue, that could be fun.
Yeah.
Especially if I'm going to take the government's side on this motion, because that's never going to do me any favors.
And chat's going to have to help me on this one. Was that also the expert that had to go through several remedial trainings for not being able to properly take a DNA test off whatever they were trying to swab?
There was something like that. I don't know if that was there, because there was one dealing with a hair, an identification of a hair. I seem to vaguely recall there was some issues with the DNA as well in relating to the lab or something else. What is this citation again? Why is it not pop? Oh, because I'm only searching federal courts. That's why. So it's not popping up because I'm restricting my search. Let's take a look at this citation. I'm always playing devil advocate. Well, I want to get the law right, regardless of my personal feelings about something. I want to get the law right.
Because if we've got something right, it should stand up to scrutiny.
Okay, let's see. Mission of evidence, expert testimony by senior criminalists, blah, 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 regarding significance, testing by another analysis did not violate right confrontation fair to confront the case of reasonable based opinion. Witness criminal opinion findings, blah, 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 blah. Blah, 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 blah.
Yeah, someone's asking if the sweater is in evidence. I'm pretty sure
It
they brought
is.
the
It has to
sweater,
be.
the sweater and all the other clothing in as evidence already.
Yeah, didn't they do that with the plexiglass? Didn't we see that earlier when they brought?
Yeah, we saw that. We saw the shoe.
Yeah. So the sweater itself is in evidence. Yes.
Yep. Okay, El Dente is telling us she used one Q-tip swab on 3 of the different holes, sent it out to California, and it took months to get results back.
Yeah. So the only okay. So there would have to have been a preliminary ruling on this issue, because one way that it would be excluded would be if the testing relating to the DNA was so unreliable that in and of itself would be a problem, then you couldn't ask a question about it because it was so unreliable. But you'd need some sort of motion in limine, and I don't think that exists.
Hank said there was something that the defense was on notice about.
Well, they were definitely on notice relating to the issue of DNA. I mean, because that
Okay.
for sure. I mean, they're definitely on notice relating to that because that was part of discovery. So it's not like the lack of DNA is a surprise.
Yeah,
They're well aware of that issue, so they weren't surprised in that sense. So if there wasn't a ruling that the DNA was so unreliable as to be garbage, if that wasn't a preliminary ruling, then any issues relating to the DNA would be going to weight, not admissibility. So you could mention those issues, but it wouldn't be inadmissible, because just because there are problems doesn't necessarily make it inadmissible. It's reasons to question, but not necessarily say it's inadmissible.
Yeah, Becky Jo's mentioning the common theorization that if the dog had been chewing on a pig ear, that's one explanation on how the pig DNA got onto the
Sure.
hoodie. But I don't know what basis, other than conjecture, the defense could bring that in.
Yeah, that is pretty conjecture, to be honest. That is a problem.
But if they get into the DNA and they bring up the pig DNA, I don't think it would be that hard for somebody on the jury to make that conclusion. I don't know that Canton is known for its wild feral pigs, but I could be wrong.
That could be a problem in some parts of the country.
Yeah.
For sure.
Oh yeah, for sure.
That could definitely be a problem in some parts of the country.
I mean, even here in Michigan, there's a law saying if you see a wild pig, you're free to shoot it.
Yeah,
we don't have any wild pigs.
No bag limit, no season, right?
Yeah, but we don't have any wild pigs. But the law exists. So.
Oh yeah.
There was one incident up here where somebody's pet pig had gotten out and somebody shot it because the law was in place. But yeah, there's no.
499 Commonwealth experts were aware of Paul Emmy opinions but could not be crossed on them. Well, Paul didn't testify, and so that's a slightly different posture. So there's that, and of course the Emmy hadn't yet testified either, so that's arguably a slightly different posture. But Russell's aware of the absence of dog DNA, yes, because she is actually part of her report. It actually goes to her report, although you do raise a reasonable point that the other expert had Paul's report and should have been questioned about it. So I think that's arguably an error as well. But I'm trying to adjudicate this one issue at the moment. I'm trying to show, should that expert, I think I said as much. I think that other expert asking about Paul's report was a perfectly proper thing because it was part of the basis of their opinion. And therefore, even if they didn't rely on it, even if they discounted it, then it would still be proper as long as they considered it because it goes to, what they did or didn't, so I don't think that's a difference worth a distinction. And I think the judge's ruling relating to that was probably an error, but I'm trying to figure out whether or not this ruling unto itself is an error, because she's probably wrong about the issue of Paul, but I'm trying to figure out whether she's wrong about this issue, assuming she's going to rule against the defense, which I assume she is. Or more to the point, what should her ruling be?
Yeah. So far, it looks like chat is leaning heavy on mistrial.
Yeah.
But like most of us in chat, I am not a lawyer, so we're just taking a guess.
I feel like I need a second legal opinion. When Commonwealth expert testifies their own opinion, the opinion is not hearsay. Yeah, that's right, of course. Yeah. Commonwealth expert and direct word testified conclusion of a second non-testifying expert would be inadmissible hearsay. I guess that's where that basis of Paul, a Commonwealth expert on direct. Yeah, but it was the defense who wanted to ask the question, so that doesn't. Although it wouldn't become hearsay just because because they're not testifying. So okay, so this then seems to be a basis for excluding Paul. Although then you run into the same problem with respect to this witness. So if this is a basis for excluding Paul, then it's a basis for excluding the DNA because it's also a non-testifying expert.
Yep.
Although, is it an opinion in the same sense?
Well, it would be, the testing of it would be an opinion, wouldn't it? Because that would be an expert you'd bring in for the collection of the DNA. And if you can't cross that expert's collection, you can't cross the testing, you can't cross the results.
The expert testimony went to the fact of test results obtained by someone else. It was hearsay. Okay, so this is a test result by someone else. They're a non-testifying witness.
Yep.
So it's hearsay because it's being offered for the truth of the matter asserted.
Correct.
So it's impermissible hearsay. But okay, if it's just impermissible hearsay, then the remedy would just be strike it, and a cautionary instruction would be sufficient to remedy the hearsay, because because hearsay isn't like a constitutional violation; it's a rule of evidence violation. So it doesn't require constitutional level remedies.
Yeah, it was Alessi's argument that introducing just the thought of DNA into the jury's mind tainted the jury beyond any other remedy.
If the conclusion or opinion of a non-testifying expert is testimonial, because a reasonable expert would anticipate the findings would be usable, its admission would also violate defendant's right to consultation because the opinion of a second expert would not be subject to cross.
Yep, that makes sense, but that doesn't change the remedy, though.
Yeah, so that therefore suggests that it's inadmissible, but it could be cured by a instruction and saying it's hearsay. So that suggests that possibility. This is very interesting. When we expanded the permissible basis of an expert to include facts or data non-evidence if the data or facts are admissible, we prohibit the expert during direct from informing the jury about facts or data she considered that are non-evidence, but would be inadmissible.
But what about cross?
It really shouldn't change cross. It shouldn't change. Yeah, if it's inadmissible in direct, it shouldn't become admissible in cross. That doesn't really make sense to me.
Well, if you keep going,
If it's here, the thrust of our rule is to leave the inquiry regarding the basis for cross. The balance between juries need to learn factual basis, dangers Commonwealth will use expert's opinion, not events fashioned by Crawford, certainly. Sixth Amendment right of confrontation, but consistent with the right of confrontation, even where the expert bases his opinion on testimonial evidence that is admissible but not admitted. Where a Commonwealth calls the expert, direct is limited to the expert's knowledge, which the expert's personal knowledge, such as training and protocol. Only defendant can open door to cross by testimony regarding the basis for opinion, which may invite the expert to testify. So is there something here, even though it's the Commonwealth who's doing it? Is there something in that logic because of the cross-examination? Although, if it's a constitutional issue, it doesn't work because the defendant can obviously waive their constitutional rights, but the prosecution can't do it. So if the basis of the defense being able to ask the question is because you're waiving the constitutional right, the Commonwealth can't pull the same trick. I am not sure whether it's admissible or not. This is a very interesting legal question. I'm not sure. The Supreme Court's decision, Melendez-Diaz, should be understood to mean the Commonwealth may not offer any opinions-based result tests by a forensic examiner unless the analysis is available to testify. We do not give that expansive interpretation.
Yeah, but this deals more with direct than it does cross, so it's not perfectly on point, but it's going to really matter on how they apply it.
Yeah.
Another one of those extremely expensive legal questions.
Could be. Implicit in the argument where forensic science has developed a point leads an objective opinion rather than DNA. Distinction between opinion and underlying facts evaporates. We recognize that where DNA offers an opinion, defendant or victim is included as a possible source of DNA. Jurors who learn about the methodology of DNA may infer the DNA profile match the DNA. The risk is the jury may infer facts, non-evidence from opinion that's admissible. It's not reason to declare the latter inadmissible unless the unfair prejudice arising from the facts substantially outweighs the probative weight. We conclude that the balance here weighs heavily in favor of admission, and the objective nature of science, underlying DNA, strengthens the opinion probative weight. So maybe because it's DNA, therefore it becomes admissible again because it's closer to being pure fact than just opinion. Because DNA is like so
this is
reliable.
Conclusory DNA, not absence of DNA.
That's true. I don't know. I don't know what I think.
I mean, I can certainly see the constitutional issue. But I'm just wondering if the defense bringing in the mechanical portion of the dog bite opens the door enough to get over to the DNA side of things. I know Alessi said they were very specifically avoiding the issue, but just because you avoid it doesn't mean it doesn't exist.
And in this case, had adequate opportunity to cross-examine as to risk, had trained, served, supervised, conducted full review of DNA, admitted to blah, 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 cross-examined as listed at blah, blah, blah. Having concluded was error. That particular defendant did not object, and these ones definitely are. Defendant's correct DNA evidence proves particularly harmful defense. Blah, blah, blah. I don't know. I don't know. You got me. I don't know. You have successfully stumped this attorney. I don't know. Based on me trying to speed read this, which is, all I can do given the time allowed, I don't know the answer to the question. It seems to me, though, that I will note that the remedy is fairly extreme, as we've discussed before. And even in Baldwin, I didn't think it was necessarily required. I didn't think the judge erred, but I didn't think it was necessarily required in Baldwin because, you know, any other remedy. So even assuming it's an error, it's probably a curable error with an instruction. To say it's an uncurable error is one hell of a conclusion, to be fair. So I don't know whether or not it's admissible, and I don't know, but assuming it's inadmissible, it feels like it could be cured. So yeah, I need a second lawyer. I need MG Law or something to join the chat. MG Law, if you want to join,
Law,
if you want to join the stream and walk me through your thinking on this, I could definitely use a second opinion. I don't always know everything, and I could definitely use a second opinion.
Yeah, I think a lot of it also comes to how
MG Law, can you join the stream? I'll send you a link.
How cautious you want to be as a judge on your remedy.
Yeah. Are you available to join the stream? Stream snipe Andrea? Maybe if I don't. You can't join, unfortunately. So yeah, I guess we could stream snipe Andrea and see what she's discussing on this point and see what she thinks. She's, of course, a criminal appellate expert. So she would be more well-informed on this point than me. He's explaining in chat. Okay, so now I have to try to read chat to try to find everything he said on the issue. So let me, I guess,
if you click on his name, you can see his chat activity, and that should.
Aha, that's a fair point. That is a fair point. I can do that. Channel activity. I can't see chat. I can see channel activity, but I can't see chat activity. Oh, there it is.
There you go. I think a lot of it comes down to how you feel if the defense opened the door or not.
Defense could waive the confrontation issue if they brought in, but state can't pierce it. Defense here was very careful. Yeah. Could be. Let's see what Andrea has to say about the issue.
And again, this comes back to judicial discretion, which is a lot of what Bev has been hiding behind for a lot of her rulings. I mean, it's obviously biased, but it's at least on the surface something you can try and wave away with that explanation.
And then see where she would go after that.
I guess I'll go back a while, see where they're discussing
Aaron
this issue.
White, Hank is purposefully conflating his focus on taken individually with taken as a whole. Shame. Guys, I got something to show you.
All right, Andrea, walk us through it.
I got a couple of things to show you. So first, we're going to look at this case. This case out of Massachusetts. Department of Youth Services versus a juvenile. This is like one of those kind of landmark cases that gets cited all the time for what is the standard for admitting an expert opinion. Let's just take a look at what they say, don't we? The issue here, the juvenile asserts that the judge should not have permitted the expert to state his opinion because the expert relied on facts, not on evidence. What facts? Family history, psychology testing, medical, neurological histories, interviews, etc. So what's the rule? The settled and traditional rule in Massachusetts is that the competency of an expert witness to testify to his opinion rests upon unusual knowledge and extraordinary experience superior to that of ordinary persons. The witness being qualified in this particular then may base his opinion upon facts observed by himself or within his own knowledge and testified to by himself, or upon facts assumed in the questions put to him and supported by either admitted facts or by the testimony of other witnesses already given or to be given at the trial, or upon facts derived partly from one source and part to the other. So they're looking at this rule 703, which we've read before, bases of opinion testimony by experts. This is actually, we're going to skip this because this was a proposed rule that was equivalent to the federal rule of evidence 703 and the rule that Massachusetts, Massachusetts never adopted a rule. They don't have rules of evidence. So the common law in the rule, they acknowledge the
All right, court's coming back, so we can't continue on. We'll try to catch up with this issue as time allows.
Please be seated for the session.
Come on, Bev, give us a lowdown. What do we got? Any grave concerns? Eye rolls? Big sigh?
All right, so the motion for mistrial is denied.
Yeah, no
Your rights are
surprise there.
Oh,
saved.
shocker.
And Mr. Brennan, you can continue with this line of questioning.
Yeah.
Yep. Okay, so absolutely no remedy
I
at
did
all.
not address sidebar, the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could we do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Oh. Yes, but not right now. They're on their way. All right. Do you have an...
I'll work around it.
Okay.
I'll work around it.
Your Honor, I would object to being done outside the jury, that it should be done like I've had to do with several witnesses in front of the jury.
Okay, if that's what the defense wants. Are you sure, Mr. Alessi?
Oh, wait, I'm sorry, let me confer with my...
And do you really want this in front of the jury or
I'm
not?
going to, yes, Your Honor, we are going to...
Oh, dear.
Yeah. It's like, do you really want that in front of the jury? It's like, yeah, no, probably not.
They're on the way, Your Honor.
Thank you.
I'll be done very quickly.
He thought
so,
better about it.
I'll have to make that decision.
When we get to the
Is the
lunch
one-
break,
are
we'll
the
go back
lunches
to Andrea's stream and listen more about this issue because I'd like to know, try to figure out
Are they
what the
still-
relevant law here is.
How long they are.
Did you start yet, or can you?
I just, if they're downstairs on their way up, I don't want to stop them.
I could do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still over this way.
Great, okay, they're going to stay.
Your Honor, if it might help, obviously, I'll be subject to whatever Your Honor does.
Oh, you need to change this caption too. I don't know what we're doing right now.
I may have 30 minutes that I could, most 35 to finish up whatever redirect that I have, if that affects Your Honor's scheduling for the jury.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it downstairs.
All right, we'll do this now.
Be quick.
Okay?
I think we're doing a voir dire now, or no, we're
Yep,
doing.
sounds like it. Mini voir dire.
Dr. Russell, during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I-
Yes. Can we turn the fan off over here, Tony, please? Or- Thank you.
Dr. Russell, did you ever review or receive that document from the defense?
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with the dog bite?
Yes.
Did you disregard it or agree with it?
I disregard, I disagree with his assessment.
Thank you. Yeah. Sorry, I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had to deal with because the witnesses disregarded it, and I was not allowed to pursue.
Damn
that.
straight.
So I do
Damn
not
straight.
believe, under the standards that's been set in this trial, the proper
Oh, yeah.
foundations.
Hold
Fair
Bev
point.
What do you
to
say
what she's
about
been
that,
saying.
Mr. Brennan? How is this any different?
Pardon me?
I'm talking.
It's
Mr.
different
Brennan.
because
How
I
is
say
this
it is.
different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility.
What? That doesn't
Showing
work.
her uniqueness and ability to determine that.
No,
these
no,
are
no, no, no.
dog
That doesn't
bites.
work. You
And
can't
so
do
when they
that.
Open their own door to vouch for their own credibility.
No.
And suggested that they're the only person or a limited person in the entire country that can do this. They should be.
She said
confronted that they
one of
are
a
not alone.
handful.
There are other
She's not
experts.
unique.
And so This isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these.
They didn't open the door by that. That doesn't make any sense.
Thank you, Your Honor. My response is this. I'll give 2 quick examples. Dr. Welcher, Trooper Paul, Dr. Scrutiny. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide.
Damn straight.
That mentioned
Damn
Dr.
straight.
Scrutiny. You'll recall that slide. They even had material.
Oh yeah, I've absolutely
from the
precluded them
car
from going there.
scene with a file name.
Yeah, if you can slice
I'm
this
not letting
difference.
it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not, for the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark it.
Okay. All right, thank you, Hunter.
So the questions are permissible now or not? I'm confused. What just happened? The questions are permissible or they're not permissible? I don't even understand
I think
anymore.
they're not permissible, but not for the reasons that
Yeah.
the defense was originally asking for.
So Brennan cannot do the questions now on DNA because for the same reason that Paul was excluded. Well, as long as it's consistent, at least that's something.
An objection.
Yeah, a small win.
Where are we? Is it in evidence now?
It's not yet. It will be.
Okay.
Your Honor, just say it in evidence.
The DNA. It's not, right?
It's not.
Okay.
Is there a question?
And
Yes,
Brennan's
it's
saying it
open.
will be is
I
an
denied the
option.
motion and allowed the line of inquiry.
So it is back in.
So
What?
it's in, but they can't reference the reports? Is that how that works?
Okay. All right. Okay, it seems questionable. How's that different again with Paul? I'm confused.
So I'm thinking they're banning the reports from coming in because they banned Paul's report and more of Welcher's report, or more of Scotty Bellow's report in Welcher. So I think they're keeping the actual reports out of the questioning, but they can question under the line of DNA.
Okay,
They just can't bring in the report's existence, I think.
okay, that kind of makes sense. I think, yeah, it kind of makes sense.
Because they don't have somebody to cross-examine on the authenticity of the report.
Right, or cross-examine the underlying report.
Yeah,
So
but
that makes sense.
Cross the conclusions that Dr. Russell made.
Yeah. I think that makes sense. But during the lunch break, we'll definitely spend more time with Andrea's stream and see if we can parse this out some more.
Back in session, you may be seated.
Jurors, I appreciate your patience. All right, Mr. Brennan.
Thank you. Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of which one specifically?
There was a gentleman
I've
lying
seen.
on the ground, his face was redacted, and there was
Oh,
some
that one,
Do
yes.
you remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was, what you were trying to deduce or
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with the car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body breaks, do you have any studies about the frequency or the likelihood of lower body breaks in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body breaks?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body breaks?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody
And
to
it
help
doesn't make
you
any difference to her
interpret
testimony.
that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding
now
this
it's okay to
allegation?
change her opinion, but
Did you
not
want to
before?
understand that before you came back and offered the same
on,
opinion you
man.
had before that information was available?
I didn't understand it, and I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had, my understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your
Precisely.
conclusions,
Somebody's
do
finally
you look at
saying
it
it
as an
before.
advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate, you're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve, yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it. Excessive saliva when it's in the moment.
Some dogs, yes.
But
And
no
some
evidence
dogs,
that it happened here.
They can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So, yes, I am aware that there were some swabs taken at some point.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion?
Objection. Thank you.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, in giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
In fact, what was found was pig DNA.
That's correct.
And there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information after you
back.
claimed there is a dog who bit John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes.
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
Yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection, Your Honor.
So the objection sustained. You can ask it differently.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA, yes?
Yes.
You can't tell us anything based in fact. Wait,
no.
I'm sorry.
Oh, sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, then you wonder why, and you want to know, was the test done correctly, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scortabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can you?
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Was I saying things? I don't even know. Was I saying things? I might have been. I know I had my microphone off, but I didn't even know if I was talking. Lol. Oh well. I might have been talking. I'm not sure. Yeah, good times. These questions seem proper. I'm definitely interested when we get to the lunch break to hear Andrea's opinions or analysis or discussion on this. These questions seem proper. How y'all doing, chat? Just a friendly reminder, by the way, check out our pinned link, Dragon's Treasure Tea. We got some great tea with a 10% discount with code UNCIVIL. You got some great teas. I can speak very positively of their teas. I've had their teas before. They're very, very good, high quality teas. So if you're a tea drinker, I do not believe you'll be disappointed. There's some very high quality teas in there. So lots to enjoy. And now they have coffee, which is more my speed. So make sure to check that out. Plus soaps. Everyone likes soap.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
The code is uncivil law.
How
Correct my own.
Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision, I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying to a reasonable degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Yes.
Correct.
That's what she's saying.
I have no further questions.
Okay.
Okay.
Mr. Alessi?
Thank you, Your Honor.
Defense definitely has some work to do on redirect. So take your time. Take your time. Especially with the hysteria stuff, you know, that's where I'd want to spend some high quality time if I were the defense. I want to spend some high quality time talking about hysteria and excited delirium and talk about how people spew all kinds of bullshit. I want to ask many, many exciting questions relating to that for quite a while. Yeah, that's where I want to spend some high quality time. Many high quality time on that. Talk about her experience in the ER, talk about things she's heard as police officer, ER, how people say all kinds of things, how people take blame for themselves when it clearly doesn't make any sense. Please ask many, many, many exciting questions relating to this, or I will be sad panda. Also, you can ask about the, you know, DNA and collision stuff, but seriously though, don't just roll over it. Just you gotta spend some time there, man.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right, and if Mr. Wolk, you could go back. Can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red-colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolk, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolk, now go to Exhibit 1. Attorney Brennan asked you several questions with regard to whether those 1/16 of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, 1/16" or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
Pretty sure no.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Well, really small piece, really big gash.
Okay. Again, there are multiple parallel
there's
abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction, because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit, well, anatomically a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause
about the same as Lex winding up in space? Too much?
You have to ask it differently, Mr. Wilson.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
No.
Not at all.
No. Not really, no.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
A little bit.
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a published standard. Do you recall that questioning?
That's pretty fine.
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies and as part of your answer. Do you recall that discussion with Mr. Brennan?
Yes.
Do those, are those studies peer reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. D. Munich, and the other one was Dr. Pollock. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties of the authors.
I'm sorry to interrupt you, Dr. Russo. Have you finished?
The specialties of the authors, yes.
We could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, for Madam Court Reporter, exhibits marked for identification P, 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 and Q, Q, Q.
All right.
And I'll start with P, 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 if I could, please. Thank you, Madam Court Reporter. May I present PPP to the, thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. DeMunich?
Yes.
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? You recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
Yes.
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
Yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxilla is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite, in which the dog can lock onto his prey. The tremendous force of the bite, muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin, and soft tissue.
Yep, it mentions patterns.
Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another.
Wow, that sounds
4
familiar.
or 5 in number, and usually found in the
case.
vicinity of the bite.
Wow.
This pattern allows differential
There's that
diagnosis
word pattern again.
with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
It supports it.
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Yep. There you go. Excellent.
Now what I would like, if I could approach Your Honor.
Okay?
Yeah, there are no studies. Yes, there are. Here's the language of the studies that mentions the word patterns and then describes the patterns in some detail. Excellent. Very good so far on
If I
redirect.
could return this to Madam Court Reporter and
Keep going, baby.
request
Keep going.
Exhibit
More.
QQQ for identification.
More, please.
Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Munich study, can you please articulate the relevant, just the relevant sections with regard to your reliance upon that study?
Yes. So this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child. And they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yeah, read that footage
Yes.
talking about the
So on page
pattern.
491, there's a section called the morphology of dog bite injuries.
What does morphology mean?
It means the shape. And so it
Morphine
goes on to say
shape.
the anatomy of a
Attracts.
dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes.
How is it relevant?
Because if not all the teeth impact, then you get a partial bite. You know, you get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes.
Oh, there's that pattern again.
Oblique
There's that word
biting.
pattern.
So what that means is not dead center on, but
so there are some
off to the side a
peer-reviewed
little bit.
there are some
Oblique
peer-reviewed papers
biting,
talking about
the biting.
patterns. Oh,
Curvature
nice.
of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Wu, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
The pattern is full, Ghost Rider.
Okay. So oblique, so we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow. And so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any, is textiles mean clothing?
Yes, and I thought
Was
you
the
meant in this
decedent-
article. But yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt or sweater shirt. So interposition of textiles, and then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know if you want to keep.
I don't want to
keep on reading.
keep reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that said.
Thank you.
Yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so, thank you, Your Honor. May I approach?
Yes.
More studies, more studies. Bring in all the studies.
So do those studies, the de Munich and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
So as to the form, Mr. Leslie?
Do those studies, each of them,
I mean,
those
that sounded
peer-reviewed
pretty open to
studies,
me.
support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did those studies look solely at individual wounds, or did those studies,
Well, the word pattern kind of suggests the answer, but
methodology,
you
look
know.
at the overall pattern to evaluate and discuss wounds from dogs?
Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the pattern, overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
They're
Important.
They're important, a little important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypothesis was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like me to give an example, like chest pain or?
Well, I'd like to give you an example of what you used here in this case as the application of that.
Well, okay, so I'm just describing the overall process, because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong, and so you have to allow for other information. And so I did that in this case. I examined the circumstances, examined the wounds photographically, and came up with my impression, but I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
I remember a question about some news clips.
And did you recall your discussion with Attorney Brennan about acute grief reaction?
Oh,
remember that discussion?
Please talk about this more,
now,
please.
In terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, they
please tell us more
acute
in excruciating detail.
Do you recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame? Can you discuss
Please tell us more
what
in
you
excruciating
meant by
detail would be my
self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
Yeah, just ask, can you please tell us more about acute grief reaction? Please. And then I'd ask questions relating, I'd ask many exciting follow-up questions relating to that. That's what I want to know the answer to.
Yeah, Leslie wasn't leading, I don't think. So I'm wondering if Hank's trying to put this out of scope now, saying she's not qualified to.
Oh no, yeah, there's not a scope problem. I mean, yeah, Brennan brought it up, so he can ask the question. It's not a scope issue. So I like what he did though with the papers. I like that he spent the time reading
that was
it.
a good
I like that he spent the time where it's like it actually uses the word pattern and like instead of just talking about just read the thing. It's like, yeah, it's there in the literature. That was very well done. I appreciated that. I wish there were more studies is my only thing, but you know, I'll take what I can get. 2 is fine.
Well, yeah, like I said before, whether or not a dog bit somebody is usually not in question.
Yep.
It's, the dog bit them. There's no real usual differential diagnosis on what else could have done it.
Please tell us using examples from your career about acute grief reaction.
Yeah, that works.
Would be my question. I'd ask, it's like, can we starting with your work as a police officer, because I'm sure it came up. It's like, can you tell us some examples where you experienced, then can you tell us about your, as a doctor, preferably in, multiple examples? Many exciting examples. Yeah, the door is very open on this point. Brennan asked the question. It is very open on this point. Assuming it wasn't open in the first place, but yeah, it's very open. Like we're just gonna live here for a while.
Probably. I figured they'd have sorted this out. It can't be that huge of an issue, but I mean, I'm assuming Leslie's pretty close to done. I don't think they'll call lunch yet.
I don't know if he's necessarily close to done. I'd want to live there for a while. So I'd just want to try to figure out how can I ask like a half hour or an hour worth of like how can I ask the same question for an hour basically? Tell us more. How can I ask that question for an hour is basically what I'd be going through in my mind. Because I want to spend some quality time here. So yeah. She's also a doctor, so I mean, apologize. She's also a teacher, so
yeah,
how other doctors have experienced it, what their reporting has been, studies relating to it might be a good idea right about now.
Oh yeah, and with as many crash victims as she's seen, there's going to be family with a fair number of them that are going to be coming in hysteric.
Yep, saying all kinds of things that don't make sense. The code for the Dragon's Treasure is uncivil law. So make sure to go back to thedragonstreasure.com. Code uncivil law for 10% off on your tea purchases. Got some. They make good tea. I can attest to their tea. It is high quality tea. They also have some other products that I'm less familiar with, but I'm sure it's good. They make some soaps. They got spices. Very exciting. Ooh, peppermint, spearmint, hibiscus. Ooh, exciting. So you can get that stuff in your life. That's promising. Then some coffee. I'm definitely going to get some coffee. We're going to have coffee experiences. I'm not sure which of these coffees is best coffee, but we'll figure it out. Something called free candy. That sounds promising. Those look like good beans. Everyone loves free candy. If you see us driving around our famous white van of freedom, be sure to stop by and pick up some coffee.
Nice.
Nice. From Ethiopia. Blueberry, chocolate, strawberry, floral, clean, consistent, balanced, bright, lemony sweetness. Sounds promising. Thedragonstreasure.com. Code uncivil law for your coffee, tea, and also soap-related needs. You got some high-quality soaps. Dwarven Fire Force soap. Exciting. Breath of Life soap. Key. Skin of the Dryads. I'm not sure what it is, but it could be fun.
Yeah. Herbs, maybe? I don't know.
Do they have a coffee-infused soap? And if not, can they make one? That would be good. Just get all the coffee infused into my body.
I'm sure they might. Didn't Duke Cannon or some other company do a caffeine-infused soap bar?
They absolutely have done caffeine-infused soaps. I have bought caffeine-infused soaps before, yes. I'm not sure how much it helped, but I definitely bought them.
Let's see. Frankie is asking if Chloe was ever swabbed for DNA. Chloe was MIA for close to 3 years until they found Cora a few months ago.
They're pulling a Don Draper. They're pulling a Don Draper.
But
it's a substitute. It's not the real thing.
No, but I don't.
Or Principal Skinner, also a dupe, not the real thing.
But I don't know that they'd even have bothered because there's nothing to compare it to because no DNA was found on the sweatshirt. So. Or at least I'm going to assume no DNA record exists for Chloe.
That was a very long sidebar.
It was.
May I have a moment, Your Honor?
Yes.
Thank you. Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Oh, unless he didn't win. We're moving on.
What the fuck? What the fuck? How? How is that not a fertile ground of questioning? Brendan specifically brought it up.
Mm-hmm.
How can I not talk about it? I'm struggling in the back of my mind to figure out the basis for not allowing these questions.
Unless this is a Lessie.
Anyone got any ideas on why the judge is apparently not allowing questions relating to this?
I'm wondering if Lessie is having to back way up to put some sort of foundation back down to get back to it, but I doubt it.
Okay. Yeah, maybe it's maybe foundation, but you wouldn't really need the foundation because the foundation was laid by Brennan asking the questions. So you don't need to relay foundation. It doesn't make sense. Okay, I'm struggling. I'm struggling to find a legal basis over here.
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation, what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Wilk, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back, not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his
There's no foundation because this lawyer that brought it up. That's not how. Yeah, that's not how foundation.
That would be toward the back of that slide presentation, probably around 130-ish, 120.
Is it because she's not a psychologist? Is it seriously because she's not a psychologist and so she's not competent to talk about grief reaction? Is that some sort of bullshit ruling by the judge?
That's what I was thinking.
Is it seriously a competency issue?
Yeah, it's beyond the scope of her
because she's not a trained psychologist, so she's not competent to talk about grief reactions. Is that seriously, because that's, as I'm struggling to find a legal basis, is that seriously the basis for which this is being excluded? She's not competent because she's not a trained psychologist to talk about grief. Is that some sort of legal bullshit that's happening right now? What the fuck? And even if it were, Brennan asked the question, so he can't then bitch about the fact that she's not competent when he raised the question. So, okay, what the fuck? I hate it.
That's it. Yes.
That's what happened when uncivil law goes through that's what happens when uncivil law goes through the logic tree in his mind and finds the basis, and he's like, what the fuck? How is this a thing? That's what happens there. Great.
What number is that? 109. So, Dr. Russell, can you...
I mean, she's only trained in forensic science and emergency room. That's not psychology. She doesn't know anything about psychology. Holy fuck.
You see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
All of it?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? The lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture.
All the fucking time.
Digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here. What is the likelihood of there being any fracture to any bone?
Pretty good.
Sustained in that form.
Do you have an opinion, based upon a reasonable degree of medical certainty, as to whether there would be any fracture to any bone?
I believe that there is a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe?
Yes.
And you've reviewed the file, the medical records files, correct?
Yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done and by whom?
By Dr. Scrutiny, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scrutiny. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
Really?
May we approach her for lunch?
All right, jurors, I'm going to send you out for lunch, okay? We'll see you at 2 o'clock. Yes, come on up.
Please.
I don't know if there's going to be more like conversation on the record or if it's just more sidebar, probably just more sidebar. So I doubt we're going to hear anything more.
Yeah, it sounded like sidebar.
All right. Well, while we're trying to do that, I'm going to go back to listening to Andrea for a while on this legal issue relating to the issue of the DNA. And then if time allows, I'll go to Emily D. Baker and listen to her discussion of it so we can patch up. I'm going to start at 1.5. So, to try to do that. So let's listen at 1.5.
Federal rule is very different, and the Massachusetts common law doesn't track that. So the proposed rule was to broaden the basis for expert opinions beyond that current in many jurisdictions to bring the judicial practice into line with the practice of the experts themselves. They're concerned about a doctor can't come in and testify because he gets reports from the patient. They tell you what their symptoms are. How do they feel? How much does it hurt? And if they can't rely on that, then how are they going to be able to give you a diagnosis? So the proper inquiry is not what the court deems reliable, but what experts in the relevant discipline deem it to be. And so, talk about all these different things that in different cases, particularly in the federal court, experts have been allowed to talk to. However, Federal Rule of Evidence 703 has been described as raising a serious potential for abuse. By permitting experts to base opinions on data not admissible in evidence, Rule 703 encourages litigators to look for experts who will base their opinions, at least in part, on evidence that is otherwise inadmissible, but which the proponents of the experts would like the juries to hear. Whether or not using Rule 703 in this manner is an abuse, it is an increasingly common tactic. You're backdooring. You're backdooring inadmissible evidence by getting an expert to rely on it. So, it's controversial. It has plagued the courts. Whether or not some places you might even be able to describe the inadmissible stuff to the fact finder, that is what is known as a backdoor. And no matter how many limiting instructions you may have, it is an ominously large door. So because of the problems, we are not persuaded we should adopt it. We should, however, take a modest step by permitting an expert to base an opinion on facts or data not in evidence if the facts or data are independently admissible and are a permissible basis for an expert to consider in formulating an opinion. Such a charge will eliminate the necessity of producing exhibits and witnesses whose sole function is to construct a proper foundation for the expert's opinion. So we're trying to balance these things, right? You can't just backdoor hearsay, but if they could get it in anyway, then we're not going to say that the expert couldn't rely on that. So if this is all that we had to consider, hey, they could call Terry Kuhn. She could be a witness. It is potentially admissible, the testing that she did. So we wouldn't foreclose it for those reasons. However, that isn't all we have to deal with because we have a confrontation problem, which is what gets us to Commonwealth versus Barbosa. So 2010 case, same kind of issue. What can the expert base their opinion on? In this particular case, I'm not going to go through all the facts because you can see it's fairly extensive, but it's about DNA testing. And so one person testifies about the results of DNA testing performed by another analyst who wasn't employed by that same department at the time of trial. So the defendant argues and the Commonwealth concedes that Delator, this is a non-testifying analyst, Delator's table showing the results of the DNA testing was testimonial hearsay, admitted in violation of the Confrontation Clause, as was Lynch's testimony conveying the information in the table to the jury. The defendant also argues that Lynch's expert opinion regarding the significance of the DNA test results violated the Confrontation Clause because her opinion was based on Delator's work product, which itself was testimonial, and essentially repeated her findings. To address this later argument, we examine the intersection between our common law rules of evidence concerning expert testimony and the constitutional right of confrontation to illustrate that our evidentiary rules in the Sixth Amendment are in harmony. So they have to establish these 5 foundational requirements to bring in the expert testimony. It will help the trier of fact. Witness is qualified as an expert in the relevant area. Expert's opinion is based on facts or data of a type reasonably relied on by experts to form opinions in the relevant field. The process or theory underlying the opinion is reliable, and the process or theory is applied to the particular facts of the case in a reliable manner. Any of those things are missing, you can ask for the Daubert-Lanigan hearing, and the judge has to perform the role of the gatekeeper to make sure that it meets a minimum standard of reliability. If here there's no motion in limine and no invocation of the judge's gatekeeper role, expert's opinion may be admitted into evidence. Where a Commonwealth expert testifies to her own opinion, the opinion is not hearsay because the declarant of the opinion is testifying at trial. Similarly, because the defendant may confront the declarant of the opinion through cross-examination, the defendant is not deprived of his right of confrontation. However, if a Commonwealth expert on direct examination were to testify to the conclusion or opinion of a second non-testifying expert, that conclusion or opinion would be inadmissible hearsay. If the conclusion or opinion of the non-testifying expert is testimonial, because a reasonable expert would anticipate that their findings would be available for use at trial, its opinion would also violate the defendant's right of confrontation because the opinion of the second expert would not be subject to cross-examination. So this comes up with DNA stuff. It has come up repeatedly in the cases. I pointed this out back when we had the original motion in limine about Carl Miyazaki, and he's going to testify as a substitute witness. All the way back in, I want to say, was it 2010? Bullcoming was decided. Bullcoming versus New Mexico. What year was that? 2011. Sorry, my bad. 2011. And dealing exactly with this issue, that if you don't have the person who did the testing at trial to be confronted about it, you're not getting a right of confrontation. You're not getting a right of confrontation if you don't get to ask the person who actually did the testing and the analysis and reached the opinions about their basis for it. If you just have some mouthpiece who doesn't have personal knowledge of any of that to just come in and vocalize this ghost tester, then you haven't been able to confront that witness. And it was just like last year or the year before the U.S. Supreme Court revisited it again, and they continue to say, no, you don't get to bring in an expert to testify about the results of testing of another DNA expert. You don't get to just substitute experts like that. It's a confrontation problem. So you don't, Hank, you don't get to go bring in defenses on notice that there's dog DNA on the sweater. That is not actually in evidence. It is not in evidence. And they don't have to concede that because
All rise.
All the judge said was, okay, Alessi, does that help? So it's not particularly informative. So Back to the discussion from Andre on this confrontation clause issue.
You haven't proved it. If you want to use that fact, it's your burden to get Terry Kuhn over here as a witness to testify so that that fact is in evidence. You just take that fact for granted and try to bring it in through your cross-examination through another expert. Then Karen is not getting to confront the expert who conducted the original testing. That's the problem. That's the problem here. And so, you know, me, I am absolutely screaming confrontation over and over and over again. If I'm in court faced with this particular problem, it isn't just a foundational problem. He's right that the foundation is at issue, but it's not just a foundational problem. It is a testimonial hearsay problem. That's why the foundation is a problem. So just one of these things that I think when you're a criminal defense lawyer, it's what you do. You're used to focusing on certain things like testimonial hearsay. For me, it's like a knee-jerk reaction. Okay. There's that joke, if you fall asleep in trial and, as soon as you wake up, very first thing you should do is objection. Anytime you hear the words, they said, or I heard, or anything like that, instantly I'm objecting to hearsay. These are kind of common sayings or ideas that are out there about legal practice. You instantly take it the next step when you're in criminal defense. Testimonial. Okay. Is it testimonial hearsay or not? And there's no question that Terry Kuhn's testimony is testimonial hearsay. She was hired by the Commonwealth for the purpose of conducting testing to prosecute Karen Reed with a crime. It is absolutely without any ground for dispute on this going to fall within the realm of testimonial evidence. So that's the problem. And I know that it wasn't said. It wasn't said. So that's disappointing. Of course, Judge Cannoni is not going to grant a mistrial. Certainly not with prejudice. With prejudice is appropriate when you have prosecutorial misconduct that has essentially goaded the defense in needing to ask for a mistrial. They don't get to poison the well and then get a second bite at the apple. So if the prosecutorial misconduct has necessitated a mistrial, then it needs to be with prejudice. We know she's not going to do that. She's not going to declare a mistrial here. The only question at all is whether she's going to allow this particular line of questioning to continue. As we sit here right now, I'm not sure they preserved a confrontation clause objection. So if Bev is being, real crafty, thinking about it, she would know, hey, confrontation isn't necessarily a bar that they have preserved to being able to consider it. It is an actual bar. It is a reason why that should not come in and it shouldn't be admissible. But if the defense hasn't raised it, then they've got the limited ability to come back later on appeal and say that was a mistake that I made because they didn't. Yeah,
that's fair. That's fair. So Andrea makes a good point that the defense might have made the wrong argument. I mean, they didn't make the right argument. So there might be enough cover in that for a decision based on that. Yeah, that could be a problem too.
Preserve it. It's constitutional magnitude. Sometimes that gives you a little bit more leeway to raise things.
Yeah.
But yeah, if I'm Bev back there being crafty, hey, they didn't raise the confrontation issue, so do I have to consider it? Well, if you were a good judge with integrity, concerned about doing the right thing, of course you would realize that whether they've said it or not, this is a confrontation problem and it shouldn't be allowed. But is that what Bev's going to do? Yeah, color me skeptical, guys. Color me skeptical. But she needed some time, needed a half hour or so. Go think about how she's going to justify what it is she wants to do.
She isn't going to say.
Spoiler alert.
She's going to thinking about all this.
Specify.
I'm just hitting you. New Orleans lady. If you can be the lead defense attorney on any high-profile case, past or present, which case would you choose and why? Oh boy, any high-profile case, past or present. Man. Which one? I mean, there's so many different reasons, why you'd want to be defense lawyer on different cases. On the one hand, the answer is, well, something that's a winnable case, BI that, has been established. We went and looked at the rules. He can't hang with the experts. So we're going for something like that too.
Dr. Russell, during the review.
Is the one
Barbosa
here
that we just read should be written in a document, placed in the court file, under her nose, revisit. But confrontation wasn't argued here.
I don't know how long they are. Did you stop yet? Or can you go? If they're downstairs on their way up, I don't want to stop them. I can do it in 2 minutes.
Interesting. Yeah. So the defense may have not made the right argument. That's possible. Cool. All right. Let's pull up Emily D. Baker's stream as well, because to see what she's saying on this issue, on the confrontation clause issue. All right, so let's see. Find where she discusses it. Give me a second, please.
Yeah, I think Andrea was making a good point on the whole ethical choice of a judge on what remedy to pick. And something like this is varying shades of gray on exactly how far down the list you get.
Mistaken by Attorney Alesi. Holy.
All right,
But
thank you. We'll give everybody.
can we just but it's not in evidence in this case before the jury.
Mm-hmm.
A half an hour. So
All right.
Well, the court is giving everyone a half an hour and gave the jury a half an hour. The court is going to resume. I think, though, it'd be a good time to take a very brief bathroom break. Let's talk about what just happened. We are still before lunch on day 26. Dr. Russell is still on the stand. There was an objection during cross-examination after Hank Brennan asked Dr. Russell if she had considered whether or not there was DNA on the hoodie. And I'm paraphrasing because we've just been through a ton of argument about this issue. There was a swift objection from Alesi, then a sidebar, then the jury was excused, then the attorneys argued in open court on the record, and then the court continued with a half-hour break. When the attorneys argued on the record, Attorney Alesi asked for a mistrial with prejudice based on the Commonwealth's question to Dr. Russell about whether she relied on or whether she knew and considered that John O'Keefe's hoodie had been swabbed for DNA. And again, that is me paraphrasing the question because we were at the end of a lot of argument. Alesi argued that this should be a mistrial with prejudice because the defense has not asked about it, the defense has not elicited it, and the Commonwealth has not presented it in evidence. Attorney Alesi argued in that Brennan has to have a good faith basis on the questions, that the questions are based on admissible evidence. Brennan argued that this can come up in rebuttal.
That doesn't
However,
work.
It's not in evidence before this jury. The prosecution elicited testimony that the entire arm of the hoodie was swabbed, and no testimony about whether that was tested. There was little bits of evidence that those swabs had been sent out and that someone had seen that in a report. There were a few mentions of it, that someone saw in a report that swabs might have been sent out. There might have been a report from someone at UC Davis. It was never followed up on, and the only reason I think I even picked up on that is because we knew about it from the first trial. So now we have Alesi saying there needs to be a mistrial with prejudice based on the prosecution insinuating that there's DNA or lack of DNA on the swab from the hoodie.
Mm-hmm.
That's not in evidence.
Mm-hmm.
The prosecution did not bring in the witness who tested those swabs.
Mm-hmm.
So there's been no conversation about the swabs. There's been no conversation about what might be potential issues with the swabs, why they might not show DNA, how long it was waited till they were swabbed, the methodology of the swabbing, how the entire sleeve was on one swab, all of the things that you would ask the person who tested it. Those were not asked because that person never testified.
Mm-hmm.
When the defense is asking for a mistrial with prejudice, what they're asking is that the court declare a mistrial and not allow the case to go forward this time or ever. Dismiss, done. Not a mistrial, we start over and do this again. A mistrial with prejudice like in the Baldwin case. That's what Alesi is asking for. Brennan argued the defense can bang their fist and yell as loud as they want, but we can ask these questions if Dr. Russell considered it. And we know Dr. Russell considered it because Dr. Russell has testified in prior proceedings that she considered it. So we can ask Dr. Russell, what did you consider? Did you consider whether or not there was dog DNA on the shirt? And Dr. Russell can answer, I didn't think about that, or I did think about that, or I discounted it entirely. So the argument from the Commonwealth is, no, she read the reports. She's allowed to consider anything in those reports, and we can ask her if she considered it or not. But the results are not in evidence. So with the results not being in evidence, that is why the defense is so frustrated with this. And the Commonwealth said the defense has always known that we were going to bring this up with our rebuttal witnesses. But if you're going to bring this up with your rebuttal witnesses, it needs to be in evidence. How do you get around it being in evidence if you're going to bring it up? Are you going to bring that in rebuttal? I imagine not. But that is what popped off before they took a long break. I have had all of the water today. I'm going to take literally 3 minutes to run to the restroom before we resume because court has gotten very spicy. But it is rare before the lunch break that I need 2 minutes to use the restroom. But today is the day because, oh my goodness, today. It is a retrial. It should not be that spicy. I don't know if the court is going to rule on this. If you have watched ahead and you know, please don't share it in the chat. We're going to watch together. But it's going to be real interesting to see how this goes and what the court allows or doesn't allow. It's not in evidence. But are there times that experts rely on things in other reports that have not been put in evidence? Yes, there are times that happens. It's going to be really interesting to see when and what the court rules on this and how. Because if this expert relied on it, you generally are allowed to consider, but this expert did not say in her direct that she relied on this as part of the things she said she relied on. She walked through, I relied on this. Mm-hmm. And she's allowed to rely on things that may or may not have been entirely in evidence. But she did not say she relied on this. And with it not being in evidence, I don't think they can ask if she considered it. But I would need to look more fulsomely at the rules in Massachusetts. But I don't think we can unring that bell, which is part of the problem. Because now the jury has heard, well, what about dog DNA? Oh boy, oh boy, oh boy. We are just in the weeds with all of it. So I'm real interested to see. But if the court considers anything, I don't see the court considering a mistrial with prejudice. I don't see the court considering that at all. And it's actually kind of surprising to me that the defense has asked for a mistrial with prejudice after we've seen them ask for other remedies so much in this case. I don't see the court granting a mistrial with prejudice. And if the court said, I am inclined to grant a mistrial, I suspect the defense would say, no, we need a different remedy, a jury instruction or something. We need a different remedy. Because the defense, I imagine, does not want a mistrial where they just do the trial again. With prejudice, it means the entire case gets dismissed, and I don't see the court going that direction at this point on this question. But we will see. I'm going to run to the bathroom for 2 minutes. Law nerds, don't forget to get the app. I probably won't ping the app when I'm back because I'm just going to go to the bathroom for like 2 minutes. We're going to take the shortest of short breaks. And
yeah, I don't see it without a foundation.
Right,
so
no
if you can build a
foundation.
foundation, I'll consider it. I do not believe that foundation has been laid yet.
But expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
If you do that outside the presence of the jury, so they don't ask questions from the jury.
Oh,
you're asking for a voir dire of your own
right now. They're on their way.
witness?
All right. Do you have an? Okay.
No, he's asking about. Let me back that up. He's asking about asking Dr. Russell about Walsh's opinion.
And has been laid yet.
But expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Let me back that up just a little bit further. He is asking to be able to ask Dr. Russell about Dr. Walsh's opinion?
Do this under court consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it.
Emily D. Baker doesn't seem like she's quite confident in the answer relating to this question either. Maybe I'm parsing what she's saying wrong, but it seems like she is not quite sure what the correct answer is here. Yeah.
Yeah.
I do not believe that foundation has been laid yet.
Okay.
But expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
If you do that outside the presence of the jury, so they don't ask questions from the jury.
No.
Oh, yes, but not right now. They're on their way. All right. Do you have an? Okay.
I mean, that's the same foundation about asking about your proposal court.
Okay. If that's what the defense wants, are you sure, Mr. Leslie?
Walsh is the rebuttal witness for the prosecution.
I do.
So they're going to do a voir dire on that.
I'll be done very quickly, so
Are the lunches here?
So they're asking to do a voir dire about whether or not Dr. Russell relied on Dr. Walsh. They're asking about when the jury is coming in. Brennan said he's going to be done quickly.
Yeah, and then they got the voir dire for the basis of the relying. So if you get past the confrontation clause issue, then you might be stuck with Massachusetts state rules. But that's interesting because whether or not that comprises a constitutional violation as a matter of the state constitution would be an interesting issue. Or is it just like some sort of other violation other than a constitutional violation? So what is the nature of the protection in the state level law is interesting. Assuming that you get past the federal constitutional. So like, yeah, so there's a couple issues here. Like one, did the defense adequately preserve the issue, which is the debate as to that. And then we can get into whether or not, despite having preserved it or not, they can still raise the issue anyway, because you can sometimes do that. Like if it's like, forget the exact language on when you can raise the issue, even though it wasn't adequately preserved, but there's some case law dealing with that issue too. But on the confrontation clause issue, assuming it was preserved, yeah, I mean, I definitely see Andrea's point, and like the case on this, like Crawford, is pretty recent. It's like 2022 or something like that. It's a pretty recent case on that issue relating to some of that stuff with experts and confrontation clause stuff. Yeah, so it might be something that would require a more robust consideration of the exact case law on this point, relating to some of this issue. And there could even be a divide of authority on some of this issue.
Could be.
Yeah. But I think Andrea's point is well taken, because it is an expert opinion. That testimony is not here.
Yep.
You can't cross-examine that because it's the state's witness, and they didn't provide it, and the defense didn't really open the door. So if you have a confrontation clause issue, then yeah, I think I would tend to favor Andrea's opinion. I don't think I can say independently that I agree, but Andrea's view seems very plausible. Would be the best I could do without doing a deep dive legal analysis.
Yeah, it'd be interesting to see if they could find any other cases other than that one to dredge up.
Yeah.
Because
that case, also the one that she dredged up, talked about DNA and seemed to talk about it in a different light as well. Although that case was not a confrontation, it didn't seem like it was a confrontation clause issue.
No,
because it seemed like it predated the relevant U.S. Supreme Court cases based on the date. It seemed like it predated those decisions. So there might be U.S. Supreme Court guidance.
It was also the Commonwealth on their direct of their own expert, not cross of the defense's expert. So apples and oranges a little bit, but is it enough to completely negate the case is the question.
Yeah. And then assuming it is an error, what is the nature of that error in terms of the right to a fair trial? And those issues could get interesting in terms of exactly where the case law is in terms of the Sixth Amendment analysis.
Yeah.
You know, if it is a failure, that would be a significant constitutional violation that would probably prevent a what would you call a clear error, or prevent a harmless error analysis.
Yes.
So normally in like an appellate analysis, you talk about harmless error, but if you're talking about a confrontation clause issue, it basically becomes a structural problem that defies a harmless error analysis. So assuming it's a confrontation clause issue, then, and assuming it's preserved, and assuming a whole bunch of other things, then it's probably prevents a harmless error analysis because it's a structural problem. And then in terms of what the remedy for that issue is, I don't know what the remedy for that issue is off the top of my head. Is it just a new trial without it, or is it, I guess it would go to whether the prosecution was like knowingly like, I don't know that necessarily.
Come back down to Bev's reasoning for her rulings, which we don't have at this point.
Yeah,
so we'd have to conjecture on
why. And almost any error except for sufficiency of the evidence. Almost any error except sufficiency of the evidence is a new trial with the defect cured.
Yep.
So you would assume, therefore, that if there is an error that was sufficiently preserved for which a harmless error analysis is improper, you would assume that the correct remedy would be a new trial with that issue resolved or prevented. Of course, this only comes up, of course, if Karen Reed is convicted, because then we're on appeal on this and other exciting issues.
So many issues.
Yeah, there are other problems. Yeah. Yeah. And it could even come down to whether or not it's a matter of the federal guarantee versus the state guarantee. And it could come down to that kind of issue. So there's that. So exciting.
Yeah. And the way Hank's been acting, it's not unreasonable to maybe consider this an induced error on his part.
But somehow, like even bigger than that, somehow for me at the moment, is the issue relating to testimony regarding this, basically the hysteria of patients. Like, why is it? Brennan asked specifically about that issue. Why can't I ask many exciting questions about that issue? Is it seriously because she's not a psychiatrist? Well, I don't know that she needs to be, because she's been an emergency room physician and has witnessed it. She may not be able to speak to the nature of the psychological phenomena, but she can speak to the nature of the reality of it. It's like, yes, as an ER physician for 30 years, I'm sure she's heard all kinds of people say all kinds of things that don't make sense. And so she could talk to that from her own experience.
Oh, yeah. And I think she can lay out her experience. You can ask her, is Karen's, conduct consistent with what you've observed?
Yeah.
Not that you have to ask her the ultimate question of, is this what happened beyond a certainty? But it is just.
But apparently, I wasn't allowed to ask any of those questions, which is the one that is blowing my mind more at the moment. So, because that doesn't make any sense to me.
Yeah.
Some of the finer points on some of the Constitution, some of the finer points in the Confrontation Clause analysis is a little bit more interesting, not for least of reasons that there's been relatively recent developments from the Supreme Court on this point. So there has been a little bit of a legal churn relating to that issue, and the Supreme Court has been applying more and more protections relating to Confrontation Clause. So there's some legal churn that's heading in the direction of the defendant, assuming that they're not even there. But like this feels somehow like this is a bigger problem. So I'm annoyed.
Yeah. I just want answers. That's what I want. I want transcripts of the sidebars, and I want them right now.
Yeah.
But I can't imagine how many weeks or months it's going to take post.
How is it possible? How is it possible I'm not allowed to ask this question? Brennan asked the question.
Yep.
How am I not allowed to ask the question? She was somehow that didn't open the door somehow or whatever. I don't know. So somehow it didn't open the door. Somehow like it didn't get deep enough into it to like open full exploration. Somehow something outside of her expertise, something else, which I don't even know how that makes sense, how it's outside of her expertise. Because, she's seen it many times, I'm sure. So, but, okay.
And I mean, her experience has been the entire basis of her certification as an expert here. So odd to do it for the whole thing and then not here.
Maybe you need to get that board certification on psychiatry too. Go for a triple. Get that additional board certification. I don't know.
I'd be interested to see what portions of her training as a Massachusetts cop may have actually been applicable to this, that there is some basis on that end of things too.
You would think I wouldn't know for sure, but I would imagine it's not exactly implausible that cops receive some training.
Oh yeah.
Relating to dealing with people, suspects, witnesses, or whatever that are not necessarily in the best state of mind.
Yeah.
I would think that might be something that you might be educated on, although perhaps not when she was in the academy. Perhaps they didn't teach that, in the dark ages. Who knows?
Or if they bothered to delineate it from any regular training that you could point to it.
Yeah. I don't know, man. It's interesting. All right, well, chat, what are we thinking? What are your thoughts? Let me read some super chats that came in, and we'll read some thoughts while we're waiting for the court to come back. Read the super chats that came in today. Greg gave $10 Australian. Cops like her getting on the stand and swearing in front of a jury to tell the truth and without hesitation to proceed to lie their asses off talking about the witness yesterday. Very much so. Michael Ladd says, "This PC builder, kudos for you seeing the wire problem most with Miss." Good catch. Thanks. Alexandra Lutz for $5.99. Thank you. Marmalade became out on civilian. Izzy W $4.99. Josh H says, "What is the dog bite community?" Good question. Granny Flowers for $2 says it's called practicing medicine for a reason. Sometimes, man, sometimes, and perhaps more than we're willing to admit, we're making shit up. We're doing our best. DL for $4.99 says, "I wish she'd say the first artificial heart." Yeah. DL for $4.99 said, "When my brother had upper and lower aorta replacement, they use Darcon tubing, which Dr. Barkley stated." Brandon for $5 said, "Fold arm at elbow." The arm does in fact fold at the elbow if everything is going correctly. The furthest left top canine teeth, furthest right, as Bob said, it's one bite. Jenny Ireland for $2.49 said, "Doing everything he can to nail her, but fails pretty much." Although I think, to be fair, he did get some stuff that he could definitely use in close. Now the defense did a lot to undermine that in their stuff, so they did a lot to like rebut that. But still, there's something he can use in close. So to the extent that there's potentials there, and he does get the last word on close. So could be powerful for him. So we can't completely ignore it. Jules has been a member for 6 months. 6 months. Jules for $2 said she may not have it, but she has a bachelor's. Josh H said the defense is arguing for mistrial. Yeah, we got to it. Potentially criminal said we all know Bev the hack will allow this garbage. Obscure Destination said I second what potentially criminal said. Maybellis for 49 said Commonwealth experts were aware of Paul ME opinions but could not be crossed on them. Yeah, that was pretty weird, right? Although Tony P pointed out correctly that they didn't like allow them to actually talk about the report itself, but they talked about the things that they didn't, which I think is consistent with how they treated Paul, because they talked about the things without actually talking about Paul's report.
Yeah, that's
so
correct.
I think the judge's rulings were consistent in this respect. So I don't think the ruling with respect to Paul and the ruling with respect to this was inconsistent on this particular issue. So we'll give her a point on that one. Obscure Destination said $2 for Tony. Jewel Ash, $7 said Lexus Space Clock Fund, the Ritz, rights, became an uncivilian. And Greg asked, how can Brent open the door about post-trauma anguish, but defense can't be asked to expand? Good questions to which we don't have answers because we don't understand the judge's legal basis. But they stood there at sidebar for a while, so I'm sure the defense had some interesting thoughts on the issue that they offered, and then they're like, no, we're not doing this. Dr. Russell should just say she's pursuing her psychology degree. Facts.
Yep, that's enough.
Facts.
When did you start? On lunch break, I submitted my application.
I mean, I believe it's true, and I'm sure someone will correct me if I'm wrong, but I believe it's true that there are some MDs who do psychology in addition to psychiatry, because the MD is more common with psychiatry, but I don't think it's exactly impermissible for an MD to be a psychologist. I think that's okay.
Oh no, there's a fair few number of people that dabble in that.
Is it maybe there's some MDs who don't actually they just actually don't prescribe medicine. They're just full-time psychologists. There's probably a few somewhere out there.
I'm sure.
It's probably okay. Probably allowable. What's the methodology for identifying taillight scratches versus bushes? Good question. Good questions had by all. Who is Colin? Colin is a vicious little punk. Preppy perjurer, as I labeled him in the last trial, who had bruising on his knuckles, which he said was due. Well, he had different stories. He said it was punching a heavy. Yeah. He said it was punching a heavy bag at one point, and then he said, I think it was when he said he fell on the ground.
Yeah, he slipped in the driveway.
He slipped, and he accidentally punched the ground. Like every other person, when they slip, causes their palm to go forward because they're trying to break their fall. Colin over here, not so much with that reaction, and just punched the ground by accident. So that was exciting. Yeah, or maybe it was due to punching someone else that night. Who knows?
Well, can we pull up the Colin Albert song? Was that Turtle Boy? Alan Jackson's Pop Pop?
Well, that wasn't. Yeah. Well, I'll beat your ass. But that wasn't about. Was that Colin? Yeah, that was Colin Albert.
That was Colin Albert.
Yeah. The Bang Bang song talking about Colin Albert. I don't think Turtle Boy would mind. We can play it.
Yeah, Jackson does that one pretty good justice. If you go back to the first trial, he was called in the Commonwealth State in Chief. They talked to him. Defense brought in a bunch of videos that he had posted on his social media talking about fighting, I think, a potential rival high school's hockey team.
Yeah.
Sports team, something like that. That was awfully aggressive.
Yeah. Yeah, he said some things. He said some things that were pretty aggressive that suggests he might have anger control issues.
A little bit.
He's a plausible alternative suspect.
I'll call this Bang Bang. Seriously? I will fuck you up. I will beat your ass. I will fuck you up. Pull up, bitch.
Colin Albert said those things.
All of these things.
I will beat your ass. I will fuck you up.
Objection.
Objection. I will fuck you up. KO. Bang bang.
He did say KO bang bang. He said that.
You're a bitch, bro. I will fuck you up. I will beat your ass. I will fuck you up. Right?
Yeah.
The bang bang, the bang bang, pull up. The bang bang, the bang bang, pull up. Right?
Yeah.
The bang bang, the bang bang, pull up. The bang bang, the bang bang.
This is a banger, Turtle Boy, I have to say. This is good shit.
All right, Mr. Lally, your next witness, please.
Yes, Your Honor, the Commonwealth will call Trooper Michael Proctor to the stand.
Yeah, he was a treat.
Oh yeah.
Please state your name and spell your last name for the jury.
Michael Proctor, Proctor.
You're a bitch, bro. I will fuck you up. I will beat your ass. I will fuck you up.
I'm going to allow it.
If only, Bev. If only.
I will fuck you up. I will beat your ass. I will fuck you up.
I'm going to allow it.
That's good shit, man. You gotta love that.
Yep. Interestingly enough, Bev excluded Colin Albert from even being called as a third-party culprit in this case.
Well, yeah, she denied it
Yeah.
as opening argument. It's like if it develops, then you can make the argument.
Yeah,
And
but they haven't even tread close to that.
no, they haven't really. I don't know how much you necessarily want to play into that as the defense.
No.
Well, they have Brian Albert, I think, because they
Brian Albert and Higgins,
to Higgins, yeah, but not Colin Albert.
but not Colin, because I think she had said it hasn't been conclusively proven that he was there that night. So
Yeah.
read into it what you will, folks.
Well, we got 15 minutes to kill, so we could just pause and come back, or you just want to take a 15-minute stretch and just leave the thing on screen for 15 minutes?
Yeah, sounds good.
All right, guys, we'll just leave the thing on screen for 15 minutes and we'll take a break. So, stretch your legs. I'm going to get some food, get some sort of nutrition. We'll be back in 15 minutes with the start of the court, so we'll see you then. Did you miss me, everyone? Court is resuming. Very exciting. I had some scrambled eggs. They were tasty and relatively healthy. With a little cheese. Nice. Eggs for lunch? Yes, it was available and relatively healthy. I didn't have a lot of food options that were ready to go. So scrambled eggs was what was available. That was, not completely detrimental to my weight loss endeavors. I don't believe she'll ever get a fair trial. Yeah. This judge is not fair. Some of these judges' rulings are very difficult to justify from first principles. Bacon is a solid choice. Bacon is fun. Welcome back, Tony. Can't hear you. There you go.
There we go. Yeah, hopefully I put the mic on. I was just saying no bacon for me.
It's sad.
No, I had a turkey sandwich. And some iced coffee. So. Kids drank all the creamer, so I had to improvise. Heavy cream and maple syrup.
Cool.
Have we heard who else is in the building today for when Dr. Russell is done?
Mm-mm.
Okay. I know they had Lucky yesterday, but whether or not that's where they're going today, I don't know.
I don't know either.
Oh, it's going to make my heart sad, though, when they do call Lucky, because Brennan is going to be brutal. The maple syrup was from local trees here in Michigan. Yeah, I wouldn't hold your breath waiting for a motion for a new judge. They did it in the first trial. They did not do it before this one. If they didn't do it beforehand, they're not going to in the middle.
You're welcome.
And if they do bring a motion, it is Bev who rules on whether or not she is herself biased. So you can imagine how that's going to play out.
Goes back in session. You may be seated.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically, we were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities, and to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, to directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the bottom of the legs near the ankle, and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw on the pictures.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but I specifically looked at the area adjacent to a very punctate little abrasion on the knee. And I looked underneath of that area very carefully on the photograph, and there was nothing. No injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
No further questions at this time, Your Honor.
Oh, okay. Mr. Brennan?
Could I inquire about scope?
See you at sidebar.
Sidebar. More exciting sidebar. Sidebars are best bars. Don't forget, we got some wonderful sidebar merch on our merch store. Definitely want to check that out. I'm
curious what scope Brendan is trying to smooth over, hash out.
Yeah.
But something tells me Hank's going to win.
Yeah. It's also interesting this judge apparently just allows infinite ping pong, in terms of cross, redirect, recross, redirect. It's just many times you guys want to talk, man.
Yeah.
It's an interesting way to run a shop.
At least they keep usually the third and fourth iterations to one or two questions. It's not infinitely large, which I suppose as long as they keep it succinct isn't too bad.
If they say they're intel, that's enough. Yeah.
Has Turtle Boy been in the gallery recently? I don't remember seeing him.
I don't think so. I think like every day he has to like win the lottery for, who gets in that day.
Okay. The defense has the guy sitting at his little portable table there behind. Wonder what he's doing every day. Ooh, jury.
One of my healthcare facilities decided to send an email to me and lots of other patients and put all of our email addresses in the open. So I'm busy. I'm busy right now trying to file HIPAA complaints.
Yep, that's a problem.
Yeah, I started sending an email to Texas, and now I'm busy filling out the forms for the federal government for the HHS having funds.
Oh, Maz wants to know who I am. To present myself, I am just Mod Tony P. Don't bother subscribing. I don't make any content. I am here to keep Kurt entertained. Maybe you entertained. We'll find out.
May I?
Yes.
Come on, Hank. Make this brief.
Dr. Russell, I asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard.
What violation? My name and email address is protected health information.
As are the hundreds of other clients.
Yes, by sending an email to everyone with their email addresses, which my email address is my name, exposes my name and my email address and exposes that I'm a patient of the facility. That would be a violation. Thank you.
Guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Lisi had you look at a couple of case files from the Journal of Legal Medicine, let me ask you about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question, so we're going to
yes, it was.
To the question, please.
Okay.
Those articles, whatever their value you think they are, they do not create a standard to apply for diagnosing or looking at a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alisi gone over these articles with you before?
Yes, we discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alisi highlighted the parts he wanted you to read to the jury?
Yes, and I believe they were the same parts that I read last time.
Could we have Exhibit 1, please? Now, regarding the Munich article, that was a case study on the unfortunate death of a young girl, yes?
Yes.
Who was attacked by or bitten by up to 3 different dogs.
Yes.
And it was a neck wound from which she bled.
Yes.
Very, very unlike what you're looking at here.
Yes, but that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you if it is different.
Oh, it is different.
Very different, isn't it?
Yes, that neck wound, yes.
Extraordinarily different.
Yes.
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
Yes.
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
Yes.
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is a puncture. If you're going to scissor, it requires a puncture, doesn't it?
It's a mechanism. It's a movement. What they're describing is a move. The way I read it, the way they described it is a movement like a scissor, where it's open and it's closed. It doesn't mean anything about how deep they penetrate.
There are no scissor bites on that wound, are there?
I don't know. I see 1 or 2 things that showed up what I think might be upper and lower, so it could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier about how these marks here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper and lower teeth.
I'm asking you about scissor bites. Please listen to my question. There is nothing on that wound that is consistent with scissor bites, is there?
I don't know.
Well, you're the expert. So when you look at that, can you point whether there's any wounds that are consistent with scissor bites?
According to their definition, and that's not an accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity, I believe that there's possibly 2 areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. Do you see any crushing or tearing in those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and I'm asking you about it.
Yes, and I'm trying to explain so that nobody gets nobody misunderstands this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Okay. Show me one puncture, anyone, on that wound.
Okay, there are no punctures on this arm that I see. However, again, the wounds don't have to have every single characteristic. It is, it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions. There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However,
I'm just asking you the question, Dr. Russell.
So you can maybe ask her.
Specifically, this study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They name 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing this article on the victim
jury's
who was
eyes
killed,
had to be glazed
do you
over by this
realize
point.
when they were giving background, this background has nothing to do with the case study. This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article? You realize that?
I realize that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
In the highlighted paragraphs that Attorney Alisi had you read, that is describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the... No, I don't agree.
Okay. I move to introduce this as an exhibit, please.
Mr. Alessi?
I have no objection, Your Honor.
Okay.
Is it 210?
In the other article that you read from, that was highlighted as well. Who highlighted the portions you were to read?
Mr. Alessi.
It's like Alessi was trying to move things along.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do that.
Do you see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed when a person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case, how fast was the defendant's Lexus traveling when there may have been an impact in this case?
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you've just given an opinion on it. Where is that number committed to or derived from?
I don't know.
Well, if you're going to give an opinion based on what you're portraying as facts to this jury, you should have some certainty about the source of your material, shouldn't you?
You know, I'm an ER doctor, so in the ER, I've treated thousands of motor vehicle accident cases. And most of the time, I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alesi, and that's why I'm pressing you on these issues.
Sustained.
Do you know, you don't know the movement of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Doesn't matter.
So when you're asked to give an opinion whether this was a clip or a direct strike, you're really not in a position, having not been an accident reconstructionist and not having been there, to give that type of information, are you?
I wasn't asked to give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about these wounds caused by a motor vehicle collision.
So you would agree with me, you are not in a position, based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event?
No, I disagree.
And so you think you can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr. Brennan,
is that true?
I have no details about the collision?
About what happened during the collision. You have no details about the body movement, the placement, the speed. You don't have any details that you know of other than what was told to you, correct?
Objection, Your Honor. Sustained.
There are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise, it depends on the location, it depends on whether or not there's continued bleeding in the soft tissues. It depends on whether there's compression of the blood vessels and or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
That's what he wants, is
yes.
ice.
So if a person was lying prone in the cold winter on the front yard on the dirt and was being covered by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature and gradual effect on the body. Now, as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Yeah, the thermal mass of an ice
Assume
pack
the weather
is
is
much
so
higher
cold
than snow.
that the cell phone battery on someone's iPhone begins to plummet regularly in degrees.
I have no idea.
That's well said, her knowledge.
Yeah. Only ever gets down to
When you
50
came to your
degrees for the phone, though.
conclusion, considering what you see in this picture and Attorney Alisi was asking you about fragments from a broken taillight. Did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Objection, Your Honor.
Sustained.
When did we ever see that in testimony?
Finally, Dr. Russell, you said during your differential diagnosis you consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces, a person by the name of John C. Walsh, correct?
Objection, Your Honor.
I'm going to allow that.
Oh, but we haven't gotten to his report. It's not been authenticated.
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Walsh and his practice?
No.
Why do you find the need to try to undermine the extent of his authority before you know anything? Why is that important?
Objection.
Sustained.
You don't know what his scope and practice is, do you?
No, but I always look at where the person works that writes the report in terms of physicians and what their possible experiences are. Do they work in a medical examiner's office in Alaska or Hawaii or a big city or a little town? I look at those things.
When you considered his opinions after his review of these materials, did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. The abrasions are non-specific. Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
I did. However, I don't know if he's ever had any experience with dog bites examinations. So I had to consider that and weigh it.
I have no further questions.
Man, this feels so out of bounds not being able to cross this report.
Yeah.
Dr. Russell, there were questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California?
That is correct. It's the second one.
With regard to these articles, you mentioned a methodology in connection with them and a pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Sustained is to the form.
Dr. Russell, what is the purpose? Let's just start with the Demunic article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
The purpose was to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed. And it just was focusing on things to look for and the patterns. It was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician to look for.
In terms of, Attorney Brennan asked, and so now with regard to the Pollock article, in terms of the Pollock article, is there any discussion in this article about whether the spectrum of injuries to which you can apply the mechanism and the methodology, is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollock speak to that?
He does.
And what does Pollock say about whether or not the spectrum of possible injury forms when you apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. So yeah, those are, and if there was material or textiles or fabric that were in between the bite and the skin, and there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Walsh. May I approach, Your Honor?
Okay. Did you show Mr. Brennan?
He's the one who gave me it.
Okay. I didn't know what you had there.
Yes, thank you. So may I hand to the witness?
Yes.
May I stand here, Your Honor?
Yes.
Thank you.
Just step back a little
Yes.
bit.
Yep. Step back a second. Dr. Russell, what I would like to do is to give the jury a fair
Objection.
I'll withdraw that.
Objection to commentary, and I'd like to be heard.
Why don't you bring the reports over? Okay.
This is not worth a sidebar.
No, it's not. Well, I've now filed a complaint with Health and Human Services and the Attorney General. I'm trying to figure out who else to file complaints with at the moment.
Yeah, I'm not sure who else you would send that to.
Yeah. It's the doctor's office, so I have to figure out who regulates the office as a whole rather than the doctor.
Yeah.
If it was the doctor, I could file it with the medical board, but it wasn't. So I have to figure out
No,
who
it's
regulates
some
the
sort of
office.
clerical error.
Yeah. Yeah, I've also emailed the healthcare agency asking, just saying, please forward me a copy of your HIPAA policy, patient bill of rights, and any other documents reflecting patient privacy and practices. For no particular reason, please send me these documents.
Ooh, going to the fan. I guess if we have to go to the fan, but are they expecting this to be a long sidebar?
What am I doing my next cooking stream? That's a good idea. I might do it today actually, because I still have my lasagna thing that I wanted to make, so I might do it today because I need food for the future. Yeah, well, yeah, I asked for a copy of the policies because the policies will probably tell me about, they will tell me about my rights and policies. And as a patient, they are required to give me that information.
Yep.
So
So
turn it over, bitch.
Proves that they know what they should be doing.
No, I'm not rolling my own sheets. No, I got pre-made lasagna. I'm gonna just put it in got some lasagna and some ricotta cheese and also some cream cheese, Philadelphia, because I thought that would be nice.
Oh, that's always good choice.
Some ground pork and pasta sauce, and throw that in the Instapot with some pepperoni. It'll be good.
Mm-hmm. I keep meaning to get the pasta roller attachment for my KitchenAid, but it's just always one of those things I think about and then never go and order, and then think about it and then don't order it.
Yeah, the doctor's office did it. The clinic manager. Yeah, sent out an email to like 60 people with all their email addresses exposed. That was good. Nice work. Good job. Oh yeah, it's a federal violation too. I filed it with HHS. I already filed it with the feds. It's multiple violations. It's federal violations, the state violations. It's multiple violations.
State too.
Yeah, that's why I filed it with the HHS. I filed it with the Attorney General, and now I'm trying to figure out what regulatory body regulates the doctor's office, and then I'll file it with them too. Multiple people can have fun with this.
Yeah, Jinx wants me to get the smoker going, but unfortunately, supper time is going to be in about 2 hours, so no time to smoke anything on that schedule.
I'm not
at least it's not raining right now.
I'm not gonna tell you the name of the clinic, AutoDoc. First of all, I could without violating my rights because, of course, the HIPAA protects me, so I can discuss my own medical issues infinitely because I'm not bound by HIPAA because I am the patient. Fuck everyone, but I'm still not going to tell you, even though I could, because why would I want to expose my privacy? That's a stupid question. The Penile Enlargement Center. Who the fuck cares? What are you talking about? Fucking bullshit. I wasn't contacting for myself though. Of course, I was contacting for Brennan. Asking for a friend.
Mm-hmm.
May I return next to the witness stand, Your Honor?
Yes.
Thank you. May I proceed, Your Honor?
Yes.
Thank you. Dr. Russell, I am re-handing you this letter from Dr. Walsh, and what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are all set.
Thank you.
Yay! No.
I'm going to have this marked for identification.
Thank you.
What are some other fun health agencies I've been to recently we can put in this discussion? It was the methadone clinic. That was it.
There you go.
Yeah.
And the next witness is who?
Sorry, Your Honor.
Who's the next witness?
If I may, Your Honor?
Yes, just tell me the name because I need to know whether we need to go to sidebar first. Okay.
Unlike some other lawyers, I made sure to get a prescription for my cocaine. So I was upset that my prescription for cocaine has become exposed. It's very sad for me. Numbrino.
Face the card and raise your right hand, please.
Just tell me the evidence you give to the court and jury in the case down here and the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Maybe see.
Good afternoon. All right, Mr. Jackson, you are all set.
Thank you, Your Honor. Good afternoon, sir. How are you?
Good afternoon, sir.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barrows, Barros.
And where do you currently work?
The town of Dighton, Dighton Police Department.
How long have you worked for the Dighton Police Department, sir?
Since 2011.
And what's your position there currently?
Currently, I am a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple of more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dighton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
2012.
Is the Dighton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your duties to oversee subordinate officers in their daily fare, whatever that may be?
Yes.
Does that include anything having to do with crime scene investigation?
To an extent.
Witness interviews?
No, that would be the Detective Bureau.
What about working and coordinating with detectives?
To an extent.
Collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature?
Correct.
All right. As a sergeant with the Dighton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are, in the police academy, we are told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know, is it true that you don't necessarily know what might become relevant later that may be needed in court?
Correct.
I want to draw your attention to January of 2022, a few years ago. January 29th, 2022, did you have any, you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
What about Officer
Did you know
Devers?
any of the witnesses or individuals involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location? I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dighton.
What were you asked to do? Why did you get that call?
The troopers said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol if you go into somebody else's jurisdiction, or anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dighton.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger?
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barrows, did you, I don't want the address, cameras are rolling. Did you respond specifically to a residence in the city of Dayton?
Yes,
Did you at that time know who lived at that residence, who resided there?
I did.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dayton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
2:30 is when he first called me and said that they were coming to Dayton to retrieve a vehicle that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle?
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow, to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company, with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Do you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever?
None.
Same with Trooper Proctor?
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes, once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works?
The whole works.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there, and I also went in to ask how we're going to get the tow truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between? Longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance.
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that
Yep.
description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you would call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And
or so.
how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
Bum, bum, bum.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked.
I bet he has new revised thoughts on cross.
Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight.
Of what?
The Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barros, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
Yep.
I am honest to God surprised he said that. I am honest to God surprised that he did not flinch or blink when it came to the moment of truth. I mean, I guess there's a Santa Claus or something. Holy shit. But he's like, yeah, I saw it, and this is not reflective of what I saw. Now, maybe he has some exciting takesies, backsies on cross or something. But I'll give him credit for the moment, man. He got to the moment of truth and be like, nope, that isn't what I saw.
Brendan is going to have to come in real hot to try and get over this.
Yeah, that'll be interesting watching that. I don't know what's going to happen next, guys. I have to be honest. I'm a little fearful about what's going to happen next because I feel like there's a lot of ways this could go wrong somehow in favor for the defense. I don't know how it's going to go wrong for the defense. I'm just worried that somehow, some way, this is all going to come back and somehow, blah blah blah. You know, whatever.
It's been too wild of a ride for it.
Pin it on the girl because that answer was way too clean. The answer is way too clean. So I'm just waiting for the other shoe to drop. Oh boy. All right, let's listen to some more, man.
What's different about this photo, sir?
That taillight is completely smashed out.
Yes, it certainly is.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Objection. Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there.
Man,
Towards that
the
right
answer's
side,
just become
where
clearer.
that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. Did you not
get the thin blue line memo?
One monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
I see. That makes a lot more sense.
Yeah,
So the way he describes that is the principal part of the housing, like all the white part basically, was covered completely. It was just basically that portion on the right that's sort of the blackish part of the housing. That was the only part that was missing. So according to him, the entire light basically was intact, essentially, except for that little part, which is more cosmetic than functional, but whatever. Yeah.
It's like a fist-sized chunk.
Yeah.
And the whole rest of it.
I'm also wondering a little bit why they didn't have this guy testify at the first trial. I guess they didn't feel like they needed it, but I've been so disappointed and so black-pilled at this trial. I'm just waiting for the sadness to come in. Please don't make me sad.
It was a fist-sized chunk of red plastic that they found later, but was not found at the scene that morning.
Yep.
So it was probably in the driveway or had fallen around someplace when Karen backed out. They picked it up and they sprinkled it with the rest.
Maybe. Could be. All right.
Yes.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Sustained.
Do you believe you would remember if the taillight, well, let me ask it a different way.
Is this bullshit?
The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
Sustained.
That was kind of
Take this
leading.
down. As you sit here and recall back to that, your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
It's a healthy length of time.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented
Possible to write a
observations,
report?
did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have.
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained.
Did he testify a year ago? I don't remember. I guess maybe
Ultimately,
he did. I don't know.
He did.
Was the black
Okay.
Lexus
Wasn't this
SUV towed and cleared from the scene?
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen, like for instance the SUV is taken away?
When I clear from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
Yep, the police report was wrong.
I'd like to show you another exhibit.
No, I'm
if
trying.
I could.
I think the Sally
This is
Port
exhibit
video showed
105.
like 5:30.
Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Describe what you see.
That tow truck is diamond towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
That date time stamp is the biggest criminal in this whole thing.
If we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Can we
Just
play this
imagine
video?
if that bar wasn't there.
Yes.
Thank you, Your Honor.
Yeah.
Very 3-point turn.
A little bit.
Can you see what's depicted?
Yeah, and that's much more
Mhm.
consistent with what he said, right? Because
Yep.
that's basically what he described.
The little
The tail
piece
light,
at the bottom.
the tail light is basically intact except for that bottom right corner. So the video reflects his observation. Yeah. Yep. So, yep.
But imagine if we had that little scrap more up higher, we wouldn't be here.
Probably not. Damn bars in the way. Screw you, bar.
Still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area. This area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13.
Can we do a little side-by-side action?
Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Lights, please.
Thank you. Mr. Brennan?
Thank you.
Are you done? Well, that's disappointing. I guess we didn't
Good
really have more
afternoon, sir.
questions.
Good afternoon.
Have we met before?
We have not.
Do you still work in Dayton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed
Nope.
or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene?
Yes.
Because it's your jurisdiction?
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it?
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you introduced yourself to them, they went into the Reed house?
Yes.
And then they came out?
They came out much later.
And that vehicle was towed?
Correct.
At no time from when you got there until you left, did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, do you know how long it took to take the vehicle from Dayton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at that moment.
Correct.
What might be important or remarkable later might
Unless
not be
you're a
remarkable
Commonwealth
at the time
witness,
you're
in which
making the
case
observation.
much clearer now.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but
Did you at the time?
at the time, correct.
Yeah. And so
Yeah, but he was only there to
sometimes difficult
observe
remember
them picking it
the
up.
details of all events, and
Wasn't
you use the report
investigating.
to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted,
We covered
it's
that
fair to
ground
say
already.
You only wrote one single line about the damage to the car.
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did the right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you
No, my
agree that
memory's
your
better now,
memory
'cause that's
that
how this
day
works.
Was probably much more accurate than it is today.
I would not.
When you wrote the report, did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't.
I did.
Inevitably,
Probably wouldn't have known he needed
you
to
were
at the time.
a witness at trial. I'm sorry, you were a witness at a prior proceeding in this case, weren't you?
Correct.
You
came in
said
and
it,
swore under
Brennan.
oath regarding your memory,
Correct.
and that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
I don't think I was asked that.
Well, were you asked to describe the best you could the damage to that right rear taillight last time you were in court on June 10, 2024?
I don't think I was told to describe it in depth.
Were you asked questions about the damage to that rear taillight last time you were in court?
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed,
Time has passed, yep.
that you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed,
Correct.
that your report was respectfully scant,
Correct.
that you had heard a lot about this case since that point, hadn't you?
Correct.
And so considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight. Is it the reason why you used that qualification to the best ability and recollection? Is it because of those human factors that had passed?
I would suppose so.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson.
Did you speak to him in person or on the phone?
In person.
Okay, okay. You're not hesitating, are you?
No.
Where did you speak to him in person?
At his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in their conference room.
Find it odd to go to somebody's hotel to speak to them about a case?
I mean, it's not like he's got a local office.
Without saying the name of the hotel, where was the hotel located?
Who fucking
Boston.
cares?
And where were you located?
I don't feel comfortable telling you.
I'm sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
Did you see him on TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Anytime these questions want to stop being stupid, I'm in for it. You mean you actually went to the conference room at the request of the defense and you spoke to them? Oh my God.
I'm just waiting for him to pull the same line that Devers was using. Is this an implanted memory? I feel that's
Attorney
coming.
Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end?
The
The good-looking one down there on the right?
No, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came into court?
No.
The photograph of the vehicle in the Sally Port, or the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever suggested that that was in any way different than what you had seen in Dayton.
Nobody asked me that.
When you were asked to describe the damage, and you were shown that photograph, you never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the taillight the day that I saw it.
That's what you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged, it was cracked, and there was a piece missing but not completely damaged.
Yeah.
Remember that testimony?
I do.
And is that accurate testimony?
Yeah.
It's accurate.
Yeah. It is accurate, yes. Yeah. What?
So, in your memory, in June 10, 2024, was that vehicle's rear taillight had a piece missing, correct?
Correct.
Uh-huh. How many times you gonna ask the question?
Damage to the taillight As you recall it when you were indicting back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
May I approach?
Yes.
Okay.
I'm going to show you your transcript of sworn testimony on June 10, 2024. And reflect on your memory, understanding some time has passed. You've testified that your memory of distinguishing that photo is reflected in your testimony, right?
Objection. So ask the question differently.
Yeah, I don't know what we're doing right now. It seems suspiciously like we're impeaching him, but we can't because he hasn't said anything inconsistent with what he said before. He said, "Isn't this what you said?" And he said, "Yes." So you can't impeach him because he's conceded the point. So what the hell are we doing now?
It's the same thing. He's just elaborating further. Nobody asked him last time.
Yeah, it's like, will it refresh your memory? Well, not really, because I already told you the exact answers.
Yeah.
What are we doing right now? It looks like we're doing you can't impeach him. He already gave you the answer. What are you doing, man? Lord have mercy.
Yeah, so I wonder if he assumed that whatever in the last trial would happen, he wouldn't have to rat them out. He realized after the fact that didn't happen, so now he decides he needs to tell the whole thing.
But but it doesn't matter either way because he's conceded the point. Like, weren't you asked last time? Yes.
Oh yeah.
Didn't you say it was cracked but not completely? Yes. Okay. I want to show your transcript to refresh your recollection. But I just agreed with you. So what are we doing right now? I don't understand.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I don't think it's what he said.
And I should take a look at there. Could you show me anywhere in your testimony, anywhere, where you made any statement about that photo being inconsistent with what you saw in Dighton on January 29th, 2022?
I also don't think that's what he said. I mean, I could go back, but I don't actually think that's what he said. Did he say that he testified about the photo? Maybe I missed it, but do I have to go back and re-listen? Because I don't think that's what he said.
He said he saw the photo in the last trial, but I don't know that he said he saw it beforehand.
Yeah, you can't refresh his recollection because there's nothing to refresh because he remembers. You can't impeach because he's already agreed to it. So nothing works. What are we doing? I don't understand. He said yes to Brent's question. He identified the photo difference. Okay, I guess we have to go back and listen to what he actually said.
I'm going to show you your 2022. You said that your memory about the damage to the taillight, as you recall it when you were indicting back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
Photo. You said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
Oh, that's ambiguous. Yeah, you said in court there's a difference between, yeah, but that's an ambiguous question because like it depends how you parse that sentence. Like you said in court that there's a difference between that photo, but did I say in court about the photo or am I saying there is a difference? So how do I parse that? Yeah, that is sleazy, bad Brennan. Bad Brennan. Bad Brennan. That is a sleazy, ambiguous question, and I'm pissed. That is not fair.
Have you ever read your testimony from? Reflect on your memory.
So ask the question differently.
Discuss the distinction between that photo and what you saw at the last.
That is not fair. That is not fair.
Could you show me anywhere in your testimony?
What a bitch.
Anywhere. Where you made any statement about that photo being inconsistent with what you saw.
See, that isn't the same thing. He didn't say that. He said they testified that there wasn't a difference between it's not the same. What a dick. What a dick. Fuck you.
2022.
I guess I got to give him points for slipping in the predicate in a way that was not necessarily readily discernible.
Well, it should be easy enough for Alessi to remedy when it gets back to redirect.
What a bitch. I tell you what, man. I don't think there's any way that I as a witness would catch that. I wouldn't I mean,
no, not a chance.
I wouldn't catch it. I'd make the mistake. I'd make the mistake too. I wouldn't catch it. What a dick. What a fucking dick. Fuck you, Brennan. Fuck you right in your double dick. I'm pissed.
Can I approach?
Yes.
I'm pissed.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was. And claimed it was.
That isn't exactly what he said.
Correct.
What a sleazy dick.
You trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example.
You don't understand the distinction, Afix? It's ambiguous. I don't know how to explain it. It's just ambiguous what he says. Like you testified at the previous trial, there's a difference between that photo and what you saw today. Now, that photo is now something I'm looking at right now. So when I hear that question, there's two ways of parsing that question. When you say, did you testify that there was a difference between that photo and what you see right now? It's like, well, relative to the photo I'm looking at right now, yes, I testified to the difference because I testified to the condition of the thing, and that's a difference based on the photo.
Yeah.
But so that's one way of parsing it. The other way of parsing it is that I testified as to that distinction at the previous trial with specific respect to the photo. So it's the way that he phrased it, it's ambiguous about whether or not the testimony at the prior trial actually concerned the photo, the differences between the photo or merely what he saw versus the photo. It's ambiguously worded and it's incredibly dickish and I hate it. I don't know if that explains it any better, but it's fucking bullshit. I'm fucking pissed.
By the academy, they teach you when you write reports to be as detailed as you can.
We all get it. Well, Affix didn't get it. That's why I said he didn't get it. Affix said he didn't understand it. That's why I took the time to pause and re-explain it on the basis that if Affix didn't understand it, perhaps his sentiment reflected other people. So on the basis that if someone had a question, and I perceived his question in good faith, on the basis that if he had a question, perhaps other people had the question, I took the time to pause and explain it. So I'm sorry that I took the time to explain to someone what they didn't understand. Sorry that that inconvenienced you, but I wanted to make sure that everyone else understood. So, you know, we can all play along at home.
Because it's a very important point, too.
The fact that memories can fade, right?
Correct.
Memories can change.
What?
Yeah, he's
I know what I saw. And that wasn't it.
Yeah, he's implying that he said that he saw the photo at the previous trial, but it's not what he said. I'm a mad panda. And now he's like, oh, your memory was wrong because you thought you saw it and you didn't, but it's not. Fucking bullshit.
What I'm asking you, because you just testified that under oath you had looked at that photo and distinguished it, but that's not accurate, is it?
No.
It's also not. Fuck you.
It's not a matter of you perjuring yourself or lying. It's a matter of
one more sound bite for the closing argument.
Yeah. Correct.
You share those same difficulties with memory as many other witnesses. Objection.
Sustained.
You have, as is human nature, difficulties with memory at times. Correct.
Correct.
And so that very certain memory.
Okay, Kurt, let's watch Riddle. I'll tell you what, everyone who complains about me pausing, I'm just going to take the time to pause and explain more. It is my channel. I will take the time to explain what I want to explain. Now, some people complain when I talk over the testimony. Some people really don't like that. They really don't like when the testimony is ongoing and then I talk over the testimony. Some people really hate that. So I've had comments in the past like, hey, when you want to comment, why don't you just pause and then comment so you don't talk over the testimony? So then I did that. And now I'm pausing and people are complaining about that. So I'll tell you what, when you guys figure out a way for me to make everyone happy all at once, we'll do that. In the meantime, I'm just going to take the time to talk about what I want to because it's my channel. And I'll tell you what, if you think that you can do it better in terms of when to comment and when not to do it, comment. If you think you can do it better, feel free to start your own channel. I'm sure it's going to be fantastic. You'll know exactly when to comment and when not. You'll know exactly how long to pause and when not. You'll know exactly every single time, and everyone will love you, and no one will disagree, and it'll be fantastic every time. I'm sure it'll be great. I look forward to watching your channel. It'll be awesome.
You had about your testimony last year, fair to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those
standard stuff.
By phone, correct?
Could have.
So the face-to-face meeting, what did you talk about?
Objection.
I'm going to allow it.
Over here.
Come on, Bev.
Excuse me.
So that, okay?
Over here.
I mean, as an attorney, I'd like to do a lot of this stuff in person. Let you get engage how that person reacts. Seems like a plausible option to me.
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this year?
Probably June. Early in this year.
Are you having some difficulty with memory about that as well?
Oh my
On a
God.
certain date,
December,
yes.
might have been January. Not 100% sure.
This year probably, or do you think you met them this year?
This year.
Do you know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
Sir, I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January? No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV and.
Was it shown to you during your
He's
conference
definitely
meeting?
watched the stream.
It was not.
So you looked and
He's a subscriber at Uncivil Law.
With all due respect,
Like,
sir,
comment,
I don't live under a
subscribe.
rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you, I'm just asking you. Have you been exposed to this case since you made those observations indicted on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory? Objection.
What a fucking dick.
Your Honor, can we approach?
Okay.
I object to this entire sequence. This is some bullshit. This is some bullshit. What a way to manufacture an issue out of nothing. Fucking wanker.
Yeah, it's really bothering me every time he brings up the word hotel, like going to a hotel that has a conference center is sleazy by the defense. I don't understand.
Isn't it true that was a flea bag motel that you were paying by the hour?
You've seen quite a bit of information about this case and the issue regarding the taillight since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
I don't want you to guess.
Incidentally, by the way, and not for nothing, although the point is slightly off, we'll spend the time anyway. This is also partially why we as lawyers tell you like just not to talk to the police in general, because police sometimes will do this too. Sometimes they will do this too. They will say things in a way that's ambiguous to try to trip you up, and then like basically no matter which way you jump, they will whack you on it because the police are really smart and where they've at least really practiced. So it's like, yeah, this is one of the things that we're concerned about. It's because, like, you know, he gave an honest answer to a dishonestly phrased question, and then it made him look like a liar or at least non-credible or unreliable because of the trickery involved in the question.
Oh yeah, they know how to set it up beforehand in your interview, so that when it does come to court, it's very easy to get you to say something else.
Yeah, and if you had a lawyer sitting by you, the odds of him catching that, even an accomplished lawyer, the odds of him catching that, oh my God, like, so it's just way too easy to slip things up, man. What a pain in the ass. Fucking bullshit. I'm mad. I'm civil mad. Grrr.
That you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
What a fucking ass. What a
I want to
fucking
show
tool.
you some evidence of that taillight before you had a chance to see it indicted.
He's answering
We
truthfully,
can have
and that just makes it look bad.
the ring video at 5:07:58, please. Have you seen this video before, sir?
I have.
Okay, before you proceed, Ms. Gilman, have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
Too many to count.
Because you were involved in this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look to compare it to your memory?
Did I have a
Yes.
particular interest? No, I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
I understand. I understand. Please play this, please. Turn the sound down. Thank you. Stop, please. Do you
Looks
see
pretty
that
red there to
white
me.
part of the back rear right taillight?
Objection.
I'm going to allow it.
You see that? Sir?
Yeah, you see the white lens on top,
Zoom
the
in a
red
little bit
lens
more.
on bottom. Zoom in, keep going.
I can.
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue. Stop it. Can you bring it back, Mr. Stone?
Looks pretty red.
Back more. Open, right there. Zoom, please. You see, sir?
I can see that.
Is that consistent with the damage that you saw when you looked at that Lexus in Dayton hours later?
Consistent.
Can we go
It's also an
to
incredibly
Exhibit
blown out
10,
video.
please? And before you show it, I have a couple questions.
Yeah.
This was a snowstorm, kind of like a blizzard that day,
Yes.
and when you got to the driveway, it had not been shoveled or plowed.
Correct.
There was quite a bit of snow accumulating and ongoing,
Yes.
and there was snow coming down on top of everything, the ground, the streets, the cars, correct?
Correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes.
When you looked at this house, when you looked at the defendant's Lexus in Dayton, you didn't go over and scoop up.
Maybe the lawyers in chat could help me out. If I were a judge in that situation, what is the proper judicial sua sponte objection for "fuck you" and "fuck your stupid question"? What is the proper sua sponte objection? The answers in chat would be appreciated.
Out into the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please?
Yeah, but to what significance, though?
Does that appear to be
Objection,
the same
sophistry?
Lexus you
I
looked
don't
at
know.
when it was in Dayton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Okay, we have Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part?
I can.
Missing, yes?
Hard to say.
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dayton? Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observation?
He would have no idea. He
I do
wasn't
not.
there.
Yeah.
The right rear taillight and the missing parts of it, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
What a dick.
Please, Mr. Jackson.
Thank you, Your Honor.
I'm surprised you left time for redirect.
I can't get over how pissed I am. That is one of the slimiest, and it was so deliberate. It was so purposeful. It was so. I am so pissed at how slimy that is. I can't even see straight right now. Is how pissed I am. Fucking bullshit.
Sergeant. Did you celebrate your birthday 2 years ago?
Yes.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain is to the form, Mr. Jackson, is
Of
your
course.
witness.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct.
You remember being in Dayton, correct? Being called out to Dayton, to the residents of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
Do you remember it was this lady, pretty lady right here in the blue?
I do.
Do you remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that? Right?
Mm-hmm.
Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dayton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sally Port in Canton PD? I'm sorry, in Canton, in the Sally Port, at the police station?
I wasn't.
At 5:30 p.m.?
Objection.
Sustain.
At any point, did you ever go to the Sally Port at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sally Port?
Objection.
Sustain.
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
I tell you what, as a judge, I'd be so pissed. I'm like, ask all the leading questions you want. Fuck you. Fuck you. The rules allow me to ask, the rules allow me to allow for leading questions on direct. Guess what? It's leading question on direct time. Fuck you with your leading objections. Sit the fuck down.
Was that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Objection.
The form, Mr. Jackson.
Of course. What were you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
Do you know who the lead detective on this case was?
By the way, you and I did meet once before, correct?
Correct.
It was in that sketchy hotel we referred to.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
So that's stricken, it's beyond the scope.
Is it?
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked, but not, or damaged, but not completely broken, correct?
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Yes.
Sustained.
Do you know whether or not I have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Did you find that unusual?
No.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barrows, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022 at about 3 or 3:15 in the afternoon when you saw the vehicle? Any
No.
difficulty whatsoever?
No.
You remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
That's all.
You would agree that your memory has changed since last time you testified in this courthouse?
Yes.
In the photo I showed you the close-up with the missing right rear taillight. Is that consistent with your memory of what you saw in Dayton on January 29, 2022?
Objection.
I'm going to allow it. It was opened
That's
up.
not an evidence.
It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set. sir.
Thank you.
Go suck a dick, suck a dick, suck a motherfucking dick, suck a dick, suck a huge smoke.
Seems like a good spot to just send you home for the day rather than bringing a witness in. So, those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media. Remember, tomorrow's a half a day, we'll finish by 1.
Oh, half day tomorrow.
Court, please. Those in openings and follow me.
That was a day.
What a dickish move.
Ooh, we get more?
Fuck you, Judge Bev. Fuck you.
Jurors exit the court, please be seated.
So there have been some motions, I think, piling up.
All right.
2, I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that. But the only one that I did read is the reciprocal discovery. Ms. Giannetti, are you examining both Brian Loughran and Karina Kolakithis?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you, sure, I have time, I just don't know what you're talking about. Sure.
Does she have time? It's almost 4 o'clock.
Now we're doing some sort of motions at sidebar, I guess. I don't know. Brennan wants attorney work product. Yeah, what else is new?
Yeah.
I tell you what, man, I don't know whether to praise him or what, or how to phrase it, but like the way he slid that in the flow and the way he threw that in so subtly, I that is so that was so incredibly deft. It's almost admirable if it wasn't being used for outright evil.
He had that one in his back pocket waiting. He knew exactly what he was doing. Well, whatever they're saying must be interesting enough because everybody is looking at the bench instead of just hanging their heads.
Maybe the judge is reconsidering that motion for dismissal with prejudice. Maybe she's giving it another look. You know what? I acted too hastily. I should reconsider that one.
Yeah. I mean, would they put it in writing?
Reconsider that motion for directive verdict. That'd be good. I know it's a little late in the day, but I've decided to reconsider that motion for directive verdict. Now's a good time. Been hunting witches in Massachusetts since 1600s. Yep. It's like the most advanced version of "Have you stopped beating your wife?" I've heard in a real courtroom ever. It's like, and then you don't even know what's happening until it's over.
Are they done?
I don't know what's happening. I just tune in for the stupid. I want to challenge Hank to a fight right about now. I think my odds are pretty good.
Oh, yeah. Okay, well, looks like they must have handled it all at sidebar then. That's no fun.
Will we ever get to the trial, the transcript of sidebars? Eventually, someday in the far future, sure.
Mm-hmm.
Well, that's not what I wanted to do. Well, we have the stream set up for tomorrow. That's good news.
Yeah, that's good. Half day. So
That's also good. That's
get a
also
nice
good.
break in there.
Today was definitely a day of frustration.
Yes.
There was issues relating to we can't cross-examine the doctor about, trauma response.
Yep.
Presumably because she's not qualified with what was
That's
she know
the only
about,
reason I could see.
What would she know about trauma response, having worked in an ER for 30 years? What could she possibly offer to the party? And then we got this stuff with Brennan, which is really annoying. And then we had a sort of interesting legal issue on the finer points of confrontation clause.
Yep, with the
doctrine.
DNA evidence.
And we had an interesting issue on that.
And Alessi telling or suggesting to Dr. Russell to ask for the transcripts. Yeah. That was a good one to open the day.
Yeah, that was nice.
But surprisingly, the smallest issue that came up.
Any chance we could do a quick review of that semantic chicanery? I don't know, man. I don't know how I want to discuss that. I don't know if I want to slice it up. I don't know what I want to do about it. I'm just so pissed. I'm just so pissed. It's probably a proper term in grammar for it. It's like probably like what is it? It's like what's it called when you have something like that? It's called a
double entendre?
No, there's like something where it's like where you can interpret like there's two ways. It's like it's like an ambiguous
okay.
clause or something. It's like there's a proper phrase for it in grammar when you have a clause that's ambiguously interpretable. It's something
like would it be an ambiguous antecedent? The question itself had two meanings, so it doesn't matter what you answer, it can be misinterpreted.
Yeah, so let me see if I can find, because I know where to find what I'm looking for. Give me a second. An ambiguous prepositional phrase, I think, was what I was looking for. I'm not sure if that's exactly right, but yeah, it's like it's ambiguous prepositional phrase because it's like it could apply to like it's like because it could apply to which part of the sentence does it apply to?
Yeah. English is a good language, everyone.
Yeah, you see that sometimes in statutes where it's like you have that same problem because you have a clause and it's like which part of the sentence does it relate to? Because sometimes the legislature makes happy little accidents and sometimes it's a little ambiguous what they wrote.
We go down that road pretty in depth with the Maya trial and some of their or they're trying to disambiguate.
He knew exactly what he was doing too.
Yeah.
There's no way he didn't know exactly what he was doing. He thought that out. He planned that. It was purposeful, intentional.
Oh yeah.
Dick. Malpromise, that's actually not bad. Malaprop, that's actually not bad. Well, it's a similar concept at least. Let's see what happened. I'm just trying to see if there was because there was, I think it's a Supreme Court decision or something.
Oh, okay.
Just checking. Okay, I guess there wasn't anything new. Some new opinions they're taking up. They didn't take up 2 gun cases after being listed on the docket something like 13 times, which is like a ridiculous amount of times to be relisted on the docket. 15. They didn't take up 2 Second Amendment issues after 15 relists. That is a fucking lot of relists. Unbelievable. So someone's trying to convince someone for quite a long time to vote for it, but they couldn't get that 4th vote. They only got 3 votes to take it up. So no Second Amendment issues for us. What a pain in the ass. Let's see. They took up 4 cases though. Let's see what we got. Challenge to a voting scheme allows elected officials count mail and ballots received up to 2 weeks after election. So postmarked by the date. So
okay.
Does postmark count? That's interesting.
I would think so, but that's just personal opinion.
Yeah, I wouldn't know the answer to that question. Petition for review of felony assault on a police officer. Former girlfriend calls the police to report that the individual had threatened self-harm and harm to the police. 40 minutes after they entered the house, police entered the home without a warrant. Police officer encountered the individual upstairs, believed he saw a dark object, and then fired and hit him in the lower arm.
That feels oddly fact-specific.
They found evidence in the home. He moved to suppress. Montana upheld the denial of the motion to suppress. Community caretaker doctrine. I thought community caretaker doctrine was dead. Didn't they kill it already? Like 2 years ago out of New Jersey? They're having another community caretaker doctrine case. I thought they already killed that.
Maybe they're taking it because they want to clarify some point on it?
I guess. I thought they already killed that. GEO Group versus Mendelssohn. Government contract claim he's entitled to sovereign immunity for work he did on behalf of the government based on collateral order.
Fair.
Interesting. It looks like it's procedural as much as substantive, though. So, and then a case dealing with guy serving in the U.S. Army wounded in a self-deletion bombing in a military base in Afghanistan. He sued the contractor under South Carolina law, breached his contract. U.S. Supreme Court threw out the claims holding Trump by Federal Tort Act. Prohibits lawsuits against government for claims arising out of combatant activity in military services. But this is against the contractor. So basically, is it Flores Doctrine? I think is the name of the case or something like that.
Sounds right.
Interesting. So can you sue the contractor if you can't sue the government? I don't know the answer to these.
But is the contractor subcontracting via the government, so would they receive the same protection as the government would?
Yeah, and it's in the scope of military service.
Yeah.
So you would think that there would be immunity.
I would think.
But the Supreme Court's going to decide that issue, I guess. So that's exciting. See what else is doing. Clarence Thomas wants the Supreme Court to decide something. Yeah, the ban of AR-15s. That's one of the cases that they didn't take up, was a ban of AR-15s out of Maryland with a 15 relists. Couldn't get in.
Oh, wow.
Couldn't get the votes. You could get, yeah.
Interesting.
It is a little aggressive as a case to take up at this time. To go right to the AR-15 issue. I think they should take more cases, but I think they should start smaller and work their way up. But that's what I think. No one asks what I think, though.
Well, I mean, generally speaking, yeah, start small, work big. Would it be nice to start at the top and take care of the biggest issues? Probably, but that's pushing the envelope.
Constitution only allows the military to be used during declared war. I don't know about that. Yeah, that doesn't sound right at all. Not for at least of reasons that if we were being attacked, we shouldn't have to declare war to bring out military troops to defend the United States. That doesn't make sense. Well, I guess we can end the stream for today, and then I'll make some lasagna or something.
That sounds like a plan.
And I'll go look at watches and try to figure
There
out
you
what my
go.
next watch purchase is going to be. I'm really like, although I can't really figure out a use case for it, that new Tudor Pelagos Ultra is definitely calling my name. If I had an extra, I think it's $6,000 just sitting around. It's like, it's a pretty attractive looking watch. I'm not going to lie. It's a good looking watch. $6,100. Does anyone, can I get $6,100 in super chats? If you guys could donate, if you guys could super chat me about $6,100 so I can buy a watch that I don't really need for a use case that I will never have, that'd be great. Thanks. Oh, super chats. Okay, let's read some super chats. Let's see. They came in. Let's see. How can Brand open the door about post-trauma anguish, but defense can't ask her to expand? Yeah, good question. Fallen Hero gifted a membership. Jim P. Out bad judges we've watched in your streams. Please rank Judge Bev and the others. Judge Bev is definitely the worst right now. I don't even think it's close. Bluefish gifted 20 gift memberships, then another 20 gift memberships. My cat's name is something. Sent 5 gift memberships. Kilo said they're good cops who knew, and then the defense, then the prosecution flambés them because they didn't get the right answer. Jen Decker gifted 5 gift memberships. Maker 499. They've been hunting wishes, watches, wishes, whatever. Thank you. I'm looking forward to Witcher 4 coming out. Looks badass.
Oh yeah, that has, I've heard.
Looks cool. I'm also looking forward to Grand Theft Auto coming out. That'll be fun. Are cigarettes approved by the FDA? No. But vape products are regulated by the FDA, but not cigarettes. But vape products are.
Yes.
Yeah. And then there was a dispute because it was actually a Supreme Court case last year dealing with whether or not vapes are cigarettes, and partially yes, for some purposes, at least some purposes. I forget the details of the case, but in some cases, vapes are cigarettes because there was some authority dealing with authority to regulate cigarettes, and the Supreme Court's like, yeah, vapes count too.
Yep.
So that's fine.
Didn't that arise out of advertisement questions?
Any giveaway today? I don't know. We could have a giveaway for fuck this bullshit, fucking stupid, fuck. We need. I need profanity laden trigger words. That's what I need for a giveaway. I don't know. Well, I guess I'll let you go. So I'll see you tomorrow, I guess.
Yep. Oh, may tomorrow please be better than today.
I'll talk to you later.
All right. Take.
Well, chat. That was frustrating. That was frustrating. That was definitely the peak. That was peak outrage today. That was very peak outrage. It's like, at least the confrontation clause question was interesting. And it's interesting not for least of reasons that there's been fairly notable development in this arena. And I think it's quite possible that there are judges sitting on the bench who possibly don't know the finer points of it, just because there's been some very interesting developments in the last couple of years relating to this. And, there's probably still some percolation of knowledge relating to this. Plus, of course, there's Massachusetts specific stuff, which makes things interesting. So, but I think Andrea Burkhart is probably right, not for least of reasons that she's incredibly smart and she does criminal appeals, so she's right in that domain. And so she would know, she would have a pretty good opinion on the answer. And it's like, yeah, but it might not have been properly preserved. So there's that problem. But then again, you might be able to raise the issue even though it isn't preserved, but that raises its own set of problems that we don't have to get into right now. In any event, I'll be on tomorrow. I'm going to go look at watches and try to make myself feel better. Maybe if I buy Judge Bev a nice Cartier or something, she'll stop being such a complete bitch. Probably not. You can hope. I've been on civil law. Till later, my friends. Cheers. Bye.